Good evening and welcome to this virtual coaching classes of the BOS of ICAI. Today, we are going to see some more, shall we say, topics that are around the fag end of the Companies Act 2013. So we've seen some of the important topics like directors and other topics. Now we are moving into an area which is sort of tested, not so frequently, but still it's important for you to know it because it deals with some important aspects of company law. Maybe in one of my earlier lectures, I might have talked about how the Indian Constitution organizes the legal framework. See, the legal framework in India, I'm sure you know it, and I'm sure I would also share with you. The legal framework consists of the legislature, which makes the law, the executive, which administers the law, and very importantly, the judiciary, which sort of acts as a safeguard in case either the executive or the citizen do not follow what is given in the law. Both parties have an opportunity to come before the judiciary. Especially, the citizen has an opportunity to go to the judiciary, the courts, to ask for some relief. When apparently or allegedly, the executive has overstepped its power. The powers of, and when I say executive, I mean the ministries. See, the executive is organized into ministries. Thereby, the parliamentarian plays a dual role because sometimes he sits in parliament making the law, and some of them come out and they become ministers and they have to administer the law. So they also become, for example, each ministry has certain things under its control. As you know, the Ministry of Finance controls the Ministry of Corporate Affairs. It's a separate ministry, though. The Finance Ministry has a very close link with the Ministry of Corporate Affairs. So the Ministry of Corporate Affairs is responsible for the administration of the Companies Act 2013. You and I are the citizens, and as such, we are impacted by the acts of the executive. And we need to be able to go to another impartial and independent authority who would hear the matter and pass judgment. So that is the judiciary. Now, in those days, I'm talking about 70s and 80s, there was no need for special bodies like the National Company Law Tribunal and all that. What was needed was the existing judicial system was perfectly capable of handling company cases also at any level. So the first appellate body itself was the jurisdictional high court, and the applicable law was the civil procedure code. So you went under the CPC to the high court, you filed the old law had courts. There were so many sections where, including your compromises and arrangements, till very recently, for about, say, 7 years ago, your compromises and arrangements were approved by courts, were cleared by the court, the jurisdictional high court had the power. But then it was found that there was a flooding of cases, you see, and by its very nature, the civil procedure code is very complicated. Okay, which is why lawyers get paid more than chartered accountants. Believe me when I say this, because there are so many things that are very technical. The plaint has to be worded in exactly a particular way, in a particular format, in that form, and it has to be filled up, signed. Everything is important. So names have to be checked up. Even a smallest error in the documentation would lead to the case getting dismissed, to the other party winning. So such elaborate, opportunities have to be given, and very, very strictly they follow rules of natural justice, so that frequently there is a delay. And in addition to that, do not between May and June. They call it as holiday. They go off. In those days, the British judges, the judges were British or Indians, but then they were of a different class altogether. The IRS and the judiciary and all, they were bigger guys. So the Babus. So they said in summer we can't work. So they used to go off on. So which is why they used to have a very, very rudimentary court working during leave. And that court will not pass and say, okay, filed. Any due date is pending for filing, you can take, you need not delay, you can file it. That's it. So 2 months. Plus, every advocate knows one very good thing. He knows how to stand up in front of the court and say, Honor, the case may be adjourned. My party is, that's all. Case will be adjourned. Either way, it will be adjourned. Anybody, and he will say, well, no more. Then only the whole thing. And between lawyers, they will have an understanding. I will not press now. I'll press later, and so on and so forth. I mean, not trying to put an aspersion. So, which means there is a lot of delay and a lot of, shall we say, traffic congestion in high courts. So somewhere they felt early 80s itself, early 80s, they felt there's a need for another body which will operate within the framework of the Companies Act 2013 and available for hearing matters relating to company law. Thus came into existence what was known as the Company Law Board, the CLB, okay, the Company Law Board. So the Company Law Board was instituted and it came within the framework of the ministry, the then Ministry of Law and Justice. Now you understand? The then Ministry of Law and Justice and the Department of Company Affairs. So the Ministry of Law and Justice also took care of the CLB, the Company Law Board. So usually the bench would have a judicial member who would be a retired High Court judge, etc. Okay, so that is how it used to be monitored. But then, over a period of time, the cases only mounted. So there was and then appeals against the Company Law Board were directly to the jurisdictional High Court. So they decided, okay, even then the Company Law Board was giving orders, but then appeals were happening. And again, the courts were getting flooded. So they said, let's have a different system altogether. And in the meantime, 1991 happens, which means liberalization, privatization. So they said courts should not have, in corporate cases, should not be delayed for so long. For example, mergers and acquisitions or corporate status. So it is a faster mechanism for doing this, and let's empower the CLB itself to do all these things. So that was 99. 1999, the law was amended, said even these powers you take it and you take care of it. So it was transferred to the CLB. The 99 law was not immediately implemented. There were some delays. Then it keeps going on and on. Then I don't know how many of you are aware of this. There were 2 aborted attempts to change the Companies Act. There was a Companies Act 2003. It means a bill which was abandoned. I think there was again a bill in 17 which was abandoned. I'm sorry, there was again a bill in 7 which was abandoned. And then the 13 bill. The 13 Act 12 Ordinance 13 Act became sort of final. So before that, there were aborted attempts. So it was all in a flux. CLB was operating, but there was always a Damocles sword hanging over their head as to when they will go away, and the new concept of the National Company Law Tribunal would come into place. Okay. Along with that, they also wanted to build an appellate framework within the law. So in the meantime, FEMA had come. Later on, we'll be talking about the Foreign Exchange Management Act, where you will see that within the framework of the Foreign Exchange Management Act, you have 2 levels of appellate authority. You have 2 levels of appellate authority, and you have 2 levels of appellate authority. So you could appeal against the orders of the NCLT. You could appeal against the orders of the Commissioner Appeals to the FIAT, the Foreign Exchange Appellate Tribunal. Similarly, under the SEBI Act, also you have the SAT. Okay, so those bodies that come into existence. So here they said, let's build a framework where even an appellate tribunal could come here within this framework. The FEMA almost is similar to the income tax framework, where you have a CIT appeals against whom you go on appeal to the ITAT, the Income Tax Appellate Tribunal, ITAT. So whereas here, the first appellate body is not the RD or somebody above him, but within the or an equivalent of an RD, but it is directly you go to the NCLT, the tribunal. The tribunal sort of hears the case, and which we're going to see today, and then passes an order. And once the tribunal is passed an order, if you are not happy with the order the tribunal has passed, you have an appellate opportunity within the framework of the act itself. You can go on appeal against the order of the NCLT to the NCLAT, National Company Law Appellate Tribunal. Now, the NCLT has been empowered and given almost all the powers of court are now with the NCLT Tribunal. Because so many sections of the act you find you have to make an application to the tribunal. So there is a lot of approval activity. The NCLT does a lot of approvals and clearing because there is a need for a judicial review. They do not want the executive to do this. They want the judiciary to do it and give the clearance. So such powers are also there. In addition to that, the appellate powers are also there. For example, under the Companies Act, there are many, shall we say, offences. So against those offences, there may be a prosecution. And if so, it is the tribunal that hears, not the court. Come to the tribunal and the matter is heard and penalty is decided, or you can go for for offences, you go to the court. When you go to the court, you can approach the tribunal for compounding. So that power is also with the tribunal. So appellate remedies within that framework of the Companies Act, wherever there is a framework of the Companies Act, you can go against the order of the tribunal. If you're not satisfied with the order of the tribunal, then you can go against the order of the tribunal to the appellate tribunal. Okay, National Company Law Appellate Tribunal. These are judicial bodies. And so in addition to that, you have what are known as the adjudicating authorities. We'll talk about them now. So today, our discussion is going to be mainly on these matters, which are fairly important. And so we will be looking at it. Yes, I gave you a lot of inputs on NCLT and NCLAT about the background so that you will understand that the background of the NCLT is hoary past. It's the earlier court, but now the NCLT and the NCLAT have come to stay and they are here. So I told you, one of the reasons or purpose for establishment of a special court, okay, was to provide speedy trial of offences. Okay, we'll come to NCLT a little later. In addition to the NCLT, the new law proposes certain special courts. This, as I told you, with regard to offences under the Companies Act, these matters go before the court. Okay, which court? Not the High Court. Sorry. Okay, they go before what is known as a metropolitan magistrate or a judicial magistrate of the first class. Before we get into special courts, let us understand one thing. These are called economic offences. Under the Companies Act, if any offence is committed under the Companies Act, it is called an economic offence. And against those offences, you can be the person who is violating the section can be prosecuted. You might have seen so many penalty sections across the Act. In all our lectures, somewhere or the other, we saw fine of 25,000 up to 1 lakh, in some cases imprisonment. So in all these cases, the prosecution will happen. There will be a prosecution. So the adjudicating authority, in this case, the regional director or an additional director or a deputy director, would send a show cause notice to the company or to the officer in default, asking him to show cause why penalty should not be levied under these sections. Right now, once a show cause notice is received for prosecution and no proper reply is given or there is no compliance, then This is a show cause notice. Next will be the prosecution notice itself. Once that is received, matter is out of the hands of the directors. It has to go to the court. Then the director would become something like the prosecutor. See, in a normal case, especially a criminal case, there would be a public prosecutor. The prosecutor's job is to put the whole facts in front of the court and say why the person should be punished. The accused, then, once the matter goes to the court, the person who has committed the offense would be given a special name. He'd be called accused. And accused, not guilty. Accused is different from guilty. Please understand. But then, unfortunately, the minute we use the word accused, automatically we have passed a judgment on the gentleman. The way the accused is treated, it is as if he has already proven that he has committed the offense. But still, he has an opportunity. He can come before the court, argue in his defense, and so on and so forth. So the defense would be the person who's being prosecuted will give his defenses. Possibly, a defense could be as simple as a director coming and saying, I didn't know about this, proving it. Or I knew about it, I objected, I gave a mail, then I resigned. Although by then this offense was committed, I was out. In every way I have said, no, this is not right. Give up. So these are all defenses. But all this happens before a court. Not high court, before a metropolitan magistrate court. I don't know if, I don't want any of you to ever have the reason to go to a metropolitan magistrate's court. But you might go when, for traffic offenses, sometimes when there's a traffic offense and you want to claim insurance, the police will say, sir, we cannot give you an FIR. If you give you an FIR, we'll also have to take you before the court. So it happened to me once because I had a small accident when somebody got injured and there was a third-party claim. So I needed to have an FIR to produce before the insurance company to transfer the liability. So the police said, sir, I will put a small case, you come with me, and we will go to the metropolitan magistrate court, and there don't do anything, just come with me. And the policeman himself, he took me to when we went to my jurisdictional for my address, which is in Chennai, the jurisdictional metropolitan magistrate is in Egmore. It's a place called Egmore where I had to go there. And so we parked my car. The policeman also came with me, and then he took me to one very, very sleazy, seedy advocate. His tie was not even. He was not even buttoning his shirt. Tie was not proper. I don't know if you knew anything about any law, but he is an advocate. Okay, he was an advocate, and he is eligible to practice. So he took me, and he knows only one thing. He'll take you there, make you stand in front of the judge, and he will say, he always plead guilty. No, this guy will never be able to take a case. If at all, at any stage, the accused is not guilty, this guy cannot handle the case after that. Because this guy knows how to do this. He goes to the court, takes the guy in, makes him stand in front of the judge at the correct time. Then the judge he will say, keep quiet, don't tell anything. Whatever he may ask you, you should say yes. That's what the lawyer will say. Because they would already have cut a deal, and this judge also will have a collection schedule. This lawyer, whatever fee he collects, everything will be distributed to everybody. And that's all. And then the fine will be paid and we walk out. Okay. Now, but then that becomes a conviction, a traffic offense. Okay. It's not a very serious offense. Don't worry. That would not have cost me my membership to the institute. But any other offense, a criminal offense, could become a disqualification. So the point I'm trying to make here is, please understand, an ordinary chartered accountant like Srikanth can afford to go once for a traffic offense. But imagine the managing director of some big shot company coming in his Audi or his Mercedes Benz. He has to go all the way to this Egmore Metropolitan Court or whichever court. In every city, I'm sure there's a Metropolitan Court. In whichever city in India you go to a Metropolitan Magistrates Court, it will be same. All sleazy characters. So as this MD of this company is going to plead, in the queue behind him, who will be standing, I'm sorry to say this, who will be standing? Pickpocket, prostitute, and a pimp. All of them will be standing there. They will also come under that. They also have to come before the Metropolitan Magistrate. So a point here is not a good thing to do. I want you to appreciate this so that later on when we come to compounding, you will understand why somebody would even want to compound. Because they don't want to or they cannot afford to go through this grueling experience of standing up in front of a metropolitan magistrate. See, if Srikanth goes and for a traffic offense and comes back, nobody knows about it, except possibly his personal secretary, the policeman. Nobody knows about it. Okay, and I pay the fine and I come out. Then the FIR, then the case is closed by the police, and then the insurance company takes over. Blah blah. Okay. In fact, the judge, the prosecutor came to me and said, "Did you drive the car? Did you drive your car at an extreme speed and dash against the victim?" Actually, I had not. I was I was giving my signal and turning left. This guy, like a mad ass, he comes and hits on the wrong side and he hits me. He hits me. But you know how it is. A two-wheeler is always a poor victim, whereas the guy who's driving the car is always the accused. That's okay. Welcome to the world. Okay, that's how it is. And I was the lawyer was holding me and he said, "Don't argue. Don't tell anything. Say yes. Did you drive very fast?" And you yes. How do you plead? I plead guilty. Okay, 500 rupees fine. Go. That's all. And something to the magistrate and something to the lawyer. Nothing big. All told 2,500 rupees. But then the point I'm trying to make is, what a shame, huh? Not for me. It's a traffic offense it's a company law violation. So in fact, imagine for a moment, this guy is produced before the metropolitan magistrate. Now, don't think metropolitan magistrate or judicial magistrate of the first class will know company law. He may not even know what is company law. I'm sorry to say this, so please don't think I'm doing 100%. He may not know. So what is the offense? Not holding general meetings, sir. Not holding AGM, sir. What, yeah? Not holding meeting. Every day people are holding meeting everywhere. All the politicians are holding meeting. Why this fellow cannot hold a meeting? I mean, he will not even understand what meeting he didn't hold and which section. All he knows, guy is accused. And there's a price list for each offense. There's a penalty. So then the lawyer will go and tell him this or this. Okay, how much you'll pay? So matter over. Okay, so I'm sorry to make such a. I mean, but then you should know, because this is also the world here. I mean, this is also part of the world you are living in. Okay, this is also this. I mean, hopefully this should not happen to anybody. But then it's an experience. Everything is an experience, right? And metropolitan magistrates. But then beauty is such cases going to the metropolitan magistrates also become more. So they said, let us establish a special court instead of making these guys, stand in front of such people along with prostitute, pickpocket. Let's create a special court where only these company law offenders will go, economic offenders will go. So they said, let's create a special court for providing speedy trial of offences under the Companies Act. So what will be the constitution? A single judge holding office as session judge or additional session judge in case of offences punishable under this act with imprisonment of 2 years or more. So a session judge or an additional session judge who can pass an order for cases of offences punishable with imprisonment of 2 years or more, and a metropolitan magistrate or a judicial magistrate of the first class in case of other offences. So where the imprisonment is 2 years or more, then the session judge. Otherwise, the metropolitan magistrate. See, the session judge is almost like a high court judge. See, the high court has sessions. This again is a very, very British thing, where the British courts, they had only one court or two courts in a county. So, for example, each county had its own court, and the county judges used to go for sessions. So they will go to each area and they will have a session court where any local cases will come up before them and they will hear it and pass an order and go. So, in fact, they used to travel and stay in a lodge or in a whole place, and then they used to go there and hear the cases, finish it. So, very, very British tradition that we still call these people session judges and additional session judges. Okay. A session is where they go out of their capital, the county capital, and they move to the other places where they sit temporarily and hear cases. So, but the word is still used, session judge or additional session judge. So in the case of any other offences, a metropolitan magistrate or a judicial magistrate of the first class would be good enough. That will be a special court which will hear only company law matters. So this person shall be appointed by the central government with the concurrence of the Chief Justice of High Court, within whose jurisdiction the judge to be appointed is working. Because believe me, every judge ultimately is top-notch, is under the control of the Chief Justice. The judges, which court they will sit in, what they will do, everything is governed by the diary, which is controlled by the Chief Justice of the High Court, right? So in Supreme Court also you have a Chief Justice. In High Courts also you have a Chief Justice. So whoever is the Chief Justice of the High Court, within whose jurisdiction you have the special court, he would have the power to do this. Now this is a important point, but not from the exam point of view, maybe knowledge-wise, you can learn this. So special courts have been formed, right? The special court may exercise the same power which a magistrate, I told you the Egmore Court magistrate, having jurisdiction to try a case, may exercise under 167 of the Code of Criminal Procedure in relation to an accused person who has been forwarded to him under that section or under that rule. So now the word has come out in open, accused person, okay, accused. See, I'm sorry I'm relating these incidents when I appeared before the magistrate court. But I also had the opportunity to appear before the Saidapet court. In Saidapet, there is another court, because in that case, the offense had happened under the jurisdiction of the Saidapet court, not the Egmore court. Saidapet is another area in Chennai, where I live. So my motorbike was stolen. I just completed my CA and I was in the beach and I parked my bike. Unfortunately, I didn't lock it. So somebody stole it. And it was harrowing. I loved that bike. And I hated to lose it. And finally, my father-in-law, would-be father-in-law, I should say, he was in police, so he managed to locate the bike. And I went behind the bike. I recovered it, bought it back. And finally, it came to Mylapore police station, where the inspector told me, if you want your bike, you have to come and appear before court and take it, because it is an evidence in my criminal case against the guy who stole your bike. I said, chalo yaar, I want it. So there's a special application for that. And luckily, I had a great lawyer friend in Saidapet High Court who said, he saw me wandering around without a clue as to what to do. He called me and said, what happened? I said, sir, this is what it is. What nonsense come? So he called one of these sleazy advocates who sort of run around these courts, and he said, hey, this guy wants this, just do it. Standard procedure. This guy took me. He said, come back in the afternoon after lunch. I will get it. So during the lunch, they actually produced the accused. Okay, they actually produced the accused. For the first time, I saw the guy who had stolen my bike. Okay, his name was Satish. I was there, and he was called. Then I was called because I was one of the witnesses, and then the judge literally barked at me. He shouted at me. He said, "Who is this, sir? His motorbike only got stolen." He looked at me and he said, "How can you be so irresponsible? How can you leave your bike unlocked?" I said, "Sir, my bike was stolen by that bugger. You're treating him like royalty, whereas I'm the guy who lost the bike, and I'm being treated like the accused here." Okay, but that's it. Welcome to the courts. Don't ever have any reason to go there, right? Don't ever have any reason to go there. It's not a nice place to go to, right? So the goal of this special court is to try all offences under the Companies Act. So when a case comes before a court, it is called trial. And that's why the word trying is used. So the judge is trying a suit or a case. Trying. So the single judge holding office as session judge or additional session judge, we already saw this. Okay, right? Now the matter may be forwarded to the special court by a magistrate or may be taken up based on police records. Oh my God. So this is, I'm slowly moving away from company law into criminal law. Absolutely. I don't know. Those of you who have had an experience in incorporating a company, I don't know if you remember when you were filling up the form for the registered office of the company, one of the points they would have asked you was for the address of the company, which is the jurisdictional police station. You'll have to find out. In fact, I used to have an index of, for when I was actively incorporating companies, there was no online facility. So I used to have a list of police stations and I used to keep it with me. So whichever address, I will see which police station it comes under and I will put that in that. So usually police stations have an alphabet and a number. For example, Adayar is J6. So J6 police station. So you have to put Adayar J6. Because then what happens, when there is a offense committed by this guy, the prosecuting director, additional director or deputy director, what he will do, he will send a show cause notice. After sending the show cause notice, some reply will come, he is happy, he is not happy. Then he will prepare the prosecution form and he will send it to the court. And thereafter, a copy will be also given to the police station. So in case the person does not appear for the first hearing, no problem. It will be given one more. Second hearing, no. Third hearing, the court will send a letter to the police station saying, produce this guy before the court. So thereafter, the police will come. Of course, it's not an arrest, but they will escort you to the court. It's a very not a good thing to happen. Okay, that is why the police records are also there. Okay, so either the special court, what happens? The special court can take it up, or from the police records they can take it up. Okay, so the High Court may exercise, so far as may be applicable, all the powers conferred on 29 and 30, which we are going to see that appeals, reference, and revision of the Code of. I'm sorry, we are going to see appeals under this Act, under the Code of Criminal Procedure. Okay, the High Court will become the appellate body. So the point is, in case you are not happy with the order of the special court, you can appeal against that within the framework of the Criminal Procedure Code to the High Court. Against the order of the special court, which is basically no more than a metropolitan magistrate court or a sessions court, you can go on appeal against that to the High Court. And so under the Code of Criminal Procedure, right, about which you and I absolutely need not bother. Just have to know that appeal against the order of this special court will be before the Honorable High Court of the state, or whichever jurisdictional High Court is there, you have to go there. Right? If a special court within the local limits of the jurisdiction of the High Court, where a court of session trying cases within the local limits of the jurisdiction of the High Court. So it will be, the High Court will be like a special court, right? As far as appellate powers are concerned, references and revision are concerned. So this is with regard to special courts. So in fact, we are in very, very, shall we say, dangerous terrain from now on. Okay, this is the darker side of the Companies Act. Okay, corporate strategy, mergers and acquisitions, so on and so forth is one thing. The other is the punishments, the prosecution. So today we are going to see that, and that will possibly be, we'll say goodbye to, I don't know, I'm sure you will be saying goodbye to the Companies Act with this, and we'll be getting into economic laws. So let's do this and let's sort of tighten our seat belt, and it's going to be a bumpy ride because some of the things that we're going to tell you are not going to be easy to digest, but then it's good to know, right? In fact, I always, again, you know me by now, I'm not a very serious person. Unless it comes to profession, in profession, I'm very serious. As a practicing chartered accountant, I'm very serious when it comes to the welfare of my clients. But otherwise in life, I'm a very, very relaxed and happy person because, as I might have mentioned many times, because I became a member of the Institute of Chartered Accountants of India, I did not sign any undertaking which said I'll stop laughing or I'll start being happy. So I'll stop being happy and I will sort of be serious. Oh, no, not like that. You can have a lot of fun. You can have a lot of, there's a lot of fun in life. For the man who feels life is a tragedy. For the man who thinks life is a comedy. So I would like to think and see life as a comedy rather than feel and see life as a tragedy. So compounding. So all these dark things, are frightening you, right? Or at least they're frightening the director. Again, just go back to your knowledge of company law. Disqualification of directors. Do you remember? If he's convicted of an offense, whether involving moral turpitude or not, and sentenced to imprisonment in respect thereof, he is disqualified from becoming a director. An offense could be even under the Companies Act. Okay. Then MD. Also, if he wants to, in an year of loss or inadequate profit, the MD can take salary even though there is a loss. For that, he has to go through a special framework. And one of the conditions they prescribe is he should not be convicted under certain specific enactments. In that case, it will be certain specific economic laws, which include the Companies Act. I don't know if if they've changed it. I'm sure they have because it's a new law, Companies Act 2013, because in that list, under the old law, they never changed it. Even after FEMA had come, they still had FERA, and so on and so forth. So the point is, any offense committed under the Companies Act resulting in a conviction, okay, conviction could result in disqualification of a person from being appointed as a director or as a managing director under the special framework for receiving, shall we say, remuneration, even in an year of loss. So that is why you should understand compounding, right? Compounding of offenses. This provision relating to compounding of offenses will be there in almost all framework laws. For example, under the Income Tax Act 1961, you have provisions relating to compounding. Okay, you can go through that. All because conviction is dangerous for corporate board members. If they are convicted, then they may not be appointed for 5 years unless they take. They can take the leave of the tribunal, but then it's a problem. So first you should understand the case is started. It's filed before the court. The court becomes apprised of the matter. Then opportunity is given to the opposite party to appear and make a defense, if at all. The defense is also heard. Sometimes the defense may be accepted. They might say, yeah, chalo, we agree with what you say. So then if the court says he is not guilty, that means he is acquitted. Opposite of convicted, acquitted. But if the court looks at all the papers and says, bullshit, you are very much liable, then they will say liable. He has to pay the fine or go to jail or whatever. That is called conviction. Conviction, acquittal. Don't say acquisition. It's called conviction and acquittal. So the person is either convicted or he may be acquitted, right? Now, if the court passes an order convicting, then he's convicted. But if you go through compounding, the record of the court will state that he is acquitted. Okay, it will be as if he is acquitted. This is something you might want to, this is something you have to understand. You will actually be acquitted if you are willing to go through compounding of offenses. What an offense is the committing of something wrong or prohibited by law. So whenever there is a law, the purpose of law is to say what you should do and what you should not do, right? That's all. That is law. Okay. I don't know. Today, a little bit poetic, remembering one of the great poems I read in my life. There are so many great poems. One of the great poems. W.H. Auden, the famous poet, W.H. Auden, law like love. L-A-W law like L-O-V-E love. Like love, it's a beautiful poem. You have to read it. Maybe Google it and find out. It's a beautiful poem, but the last lines are very important. Like law, like love. Like love, we know not where or when. Like love, we know not where or when. Like love, we seldom keep. Like love, we often weep. It's a beautiful lines. Like law, he says, is like love. Because like love, we do not know where or when. Because where I will commit this offense, when I will commit this, we do not know. Where or when. Like law, we seldom keep. If there is a law, believe me, violation is more a norm than maintaining the law. Okay, and today there are so many offenses that if you want to obey all the laws in this country, believe me, you better stay quarantined for your whole lifetime. Corona is the best option for us. Because you're not going out, no offenses will be committed, right? Because you walk on the street, you're committing some offense or the other. You drive a car. See, I don't know how many of you read the Motor Vehicles Act, right? Recently, one client came to me and said, we want to start a new project for pet ambulance, for carrying a pet, okay, dog or cat or whatever he is having as a pet. And he says, he told me under the Motor Vehicles Act, carrying a dog or, taking a dog or a cat in a normal motor vehicles act. I don't know. So I've seen so many dogs putting their heads out of the window and their tongues are lolling out. And sometimes they're nice dogs, even wave at them. The point here is it's an offense under the Motor Vehicles Act. Okay. I believe they met the police commissioner who actually told this. Then they asked, why have we not prosecuted these people? How many people can we prosecute? These guys are just taking it. How can I prosecute? See, the problem is a law should say something which it is possible for the executive to monitor and control. A law cannot say something and then the executive should have the capability to control it and monitor it. So such a law needs to be reviewed. That's all. In a democratic process, a law which has lost its meaning has to be reviewed or revised or scrapped if it has lost its meaning. Okay, is the point. So whatever may be the law, I assure in this country or in any country, but then you see, it's in India, most of the time we ignore these offenses. Okay, we don't prosecute because with this population and with so much violations, if everybody is prosecuted for every law that they have violated, we will need umpteen courts. Everybody should become a judge. Otherwise, the number of judges is not enough to try these cases. Okay, so this is the problem with the man who thinks foreign life is always a comedy. So, but then Companies Act at least has a clarity there. There are offenses, with section, and who is the person who will see for Motor Vehicles Act offense, the appropriate authority is the police department. Similarly, for an offense under the Companies Act 2013, the appropriate ministry is the great Ministry of Corporate Affairs. So they will only watch, they are the watchdogs and the bloodhounds or whatever they are, and they keep on looking at you. They go through the balance sheet, they go through the papers filed. You read inspection and investigation. Do you remember when you read inspection and investigation? At the end of an investigation, there could be criminal proceeding. If you remember, link it there. At the end of the investigation, the investigating officer could initiate criminal proceedings under n number of sections, whichever section there are. Okay, so once the offense is committed, okay, something is done which is prohibited by Companies Act 2013, then please understand there's a difference between a crime and the violation of any law. Okay, offense includes a crime, but crime is part of offense. All offenses need not be crimes. Any violation of any law is a crime, right? Violation of any law is a crime. But, I'm sorry, crime is an offense, but all violations of law are not necessarily crimes, okay? Except fraud. See, when specifically under the Companies Act 2013, you have certain sections which very clearly say this would be a criminal offense. For example, misstatement in prospectus has two consequences. One, action under civil law by somebody who has suffered a loss. Secondly, action under criminal law by the government against the person, because a crime is an offense against the whole of the country. So every citizen. So when a crime is committed, everybody is offended, and therefore the person who has committed the crime has to be punished, right? So that's a crime. Similarly, for violation of any law, but all violations are not crimes. For example, not holding an annual general meeting is not a crime, but it is an offense. Okay. So sometimes an omission to perform a duty imposed by law is an offense. For example, not holding the annual general meeting, not filing the annual return, not filing the financial statement. These are all offenses. And we also know what is the penalty, which you studied in your your IPCC or whatever, and you know about the penalty for it. So how will that happen? If not filed at all, he will prosecute. Okay. And once the prosecution is initiated, you know what's going to happen. You go to the court, metropolitan magistrate, prostitute, pimp, pickpocket. You want to avoid all that? You don't want to go through this? You want to be free? You want to get acquitted? Then the law gives you the opportunity to go for compounding. Compounding comes as a sort of a solution. But then all offenses under the Companies Act, this is important. Even from the exam point of view, this is important. Please listen. All offenses under the Companies Act are not compoundable. Okay, so here's the checklist. If the offense involves fine only, then it is compoundable. Absolutely no problem. For example, there are certain offenses where there is no penalty. Then, a special section is there for you to fine. no imprisonment, only fine, no problem. Fine only, no problem. Fine or imprisonment, or, which is why whenever I taught penalty to you in my earlier classes, I used to either highlight or put it in a special box and put it in highlight or keep on stressing fine or imprisonment. Because, and I also might have told you at that time, when we come to compounding, you will understand the importance, because offenses which involve fine or imprisonment are compoundable. Similarly, some offenses will say fine or imprisonment or both. Fine or imprisonment or both. So the minute you see the word or, the offense is compoundable. But fine and imprisonment, then the offense is not compoundable. You cannot compound it, which means, I'm not saying it's not compoundable at all. I'm saying it's not compoundable under the Companies Act. Now, for fine and imprisonment, the regional director and the tribunal are not responsible. It's a criminal offense. So you have to go under the Code of Criminal Procedure, where the High Court has the power to compound. So you have to go to the High Court and get your offense compounded. So it's not as if you cannot compound the offense. Please understand. You cannot compound it under Section 441, under the Companies Act 2013. That's all. This is for your clarity. Okay, as far as if you're asked the question in the examination, an offense involving fine and imprisonment is not compoundable. Which means, at least try to remember those sections which are fine and imprisonment. For example, declaration of dividend, those offenses mean this framework is not available to you. This is an easier framework. Relatively easier. Okay. So one of my relatives has two daughters, and we were talking about them when I said, the first daughter is a good girl. They said, what do you mean she's a good girl? I said, come on, relatively speaking, she is good. When compared to her sister, she is good. Okay, so relatively speaking, the compounding of offenses under the Companies Act is less gruesome than under the Criminal Procedure Code. So that's all. Okay, both are bad. One is the lesser evil. So because it's not as if you can just go there and say, hey, you know what, I want to compound. Oh, really? Come on, compounding. It's a huge fine. Sometimes 3 times the fine you have to pay. 3 times the fine you have to pay. It's not as if you pay less when you go for compounding. You see that. If it is pure imprisonment only, then also the offense is not compoundable. You cannot compound the offense. But the advantage is, once compounding is approved, then the regional director or the tribunal will inform the court and the proceedings will be dropped. Also, in the records of the court, the person who is accused will be love this section because fantastic job for them. They love to do this. So compounding is the only way out if you are if you have committed, right? So be very clear about where it is a little bad. So I'm so sorry. I hope now it's fine. I'm sure it's better now. Let us see, because sometimes my connectivity. As I was telling Mr. J, I'm now in a city called Salem, not in my hometown called Chennai, or in the other place where I stay regularly called Coimbatore. Now I've come here for an audit. I'm in Salem, so possible then, I don't know. Okay. We got the right one. Yeah. So most of the presentation of directors has not been. I'm not teaching company law. I'm not teaching characters. I'm teaching company law. And yeah, there are some PowerPoints that need to be shared, and I will do it. ASAP, I will do it. I'm very busy with, you know how it is, 28th February, thanks to all these, extension. We are caught in a mess, and everybody is coming at the last moment. Plus, the time barring cases in income tax, faceless and faceful, whatever assessments, blah, blah, blah. So it's life is a hell. But okay. And Anjali, I totally agree with you. Definitely it's a movie to enjoy. And please ensure that in that movie you are the heroine. Okay. And in each one of yours movie, you are the heroine and you are the hero. And you have the right to do whatever you are. You have the right to change the script. I think if you've seen the movie called Matrix, at the end of this, whole thing is a program. It's a code. So if assuming it's a code, who writes the code? So when we start writing our own code, automatically we become the hero or heroine of the movie we live in, right? So good. Moving on. Who can compound? The power. As I already mentioned, these two guys have it. The regional director and the tribunal have it. So the maximum fine up to and including 25 lakhs. So where the maximum fine is up to 25 lakhs, the RD himself can compound. Which is why our friends, the company secretaries, love the section 441, because all they need to do is take you by the compounding. Company secretary, RD, chartered accountant. Oh, you are a bad boy. You are always committing offenses. Don't come to me. Regional director doesn't like chartered accountants. When you go there, you are a chartered accountant. Don't you even know this? As if CA means everything you should know. There is no way he can be ignorant. Or sometimes he might have. No. If you even the slightest mistakes, they'll say, you are a chartered accountant. You don't even know this? Okay. But whereas company secretary may sort of big hole, but they'll say, chalo, no problem. Good boy. Don't worry. Next time you do better. Something like that. I don't know. How these guys became the pets of the regional director, possibly because that institute itself was a sort of what shall I say, a child of the Department of Company Affairs. It came out of the Department of Company Affairs. As you know, in mythological stories, one god will come out of another god. So like that, this institute came fully born out of the Department of Company Affairs. Unlike us, we were already there and we were chartered. These guys were not there. Then the government gave them so they have a sort of a parental love towards this institute and its members, and they like to protect them and give them opportunities. We are orphans. Nobody is there to protect us. Everybody is out to hit us. And if anything goes wrong, CA, catch him, put him in jail, hit him, insult him in public, write nasty articles about him. Okay, say whatever you want about him because he's open game. You can do whatever you want with this guy. Okay, something like that. That's quite unfair, but then that's how life is. So where the maximum fine exceeds 25 lakhs, then you have to go to the tribunal, right? Okay. Now, the offense will be compounded on payment or credit by the company or the officer to the central government of such sum as that tribunal or the RD or any other officer authorized by central government may specify. Okay. So, provided that the sum so specified shall not in any case exceed the maximum amount of the fine which may be imposed for the offense so compounded, right? So, in fact, under the Income Tax Act, it's as high as 5 times. Okay, but here they restricted to the maximum amount. So all you need to do is pay the maximum and go singing happily on your way. Compounding is possibly from the exam point of view also, this is important because they might give you a problem where they might give a story of an offense and then ask you, then just remember that the maximum fine up to, they might ask you who can compound, whether the offense can be compounded, then who can compound, right? And what is the maximum, how much can be the compounding fee? It's called compounding fee. Right? And don't think compounding means something like an outside wall compound. No. The root of the word compound, the verb to compound, okay, comes from the noun composition of offense. composition. Okay, you compound means you are making composition. Okay, you're sort of agreeing. You're saying, "Chalo, what has happened has happened. Do your worst. Please find me. Let me go. Acquit me. Let me not be, shall we say, prosecuted and found guilty." So now this is as far as compounding is concerned. I think it's pretty clear. And moving on, offences under the Companies Act are to be non-cognizable. See, let me see how. I don't know if Sumit is there very much, and okay, Mr. Deepesh Mishra also. I hope Deepesh can hear me better now. He's also from Jaipur. Okay, so the point here is, what is a cognizable offence? Anybody, just quickly. I don't know how interactive can this be, but let's see. Quickly, what is a cognizable offence? Let's talk about non-cognizable. First, what is a cognizable offence? Whatever you think, I know some of you may not know it. What is a cognizable offence? You know, I was taught Civil Procedure Code and Criminal Procedure Code by the gentleman whom I told you I met in Hyderabad Court. He was my teacher. I was referred by my guru, Professor K. Anantaraman, when I was studying for ACS, for when I studied law. This is general laws. They had CPC and CRPC in that syllabus. Everything. IPC was not there. Evidence Act, CPC, CRPC, everything was there. So for CPC, CRPC, Evidence Act alone, I was directed by my guru to this gentleman. His name is Mr. Raghunathan, a very, very leading lawyer in Chennai, a very good person. And I was told to go to him, and I went to his office where, only 3 of us will be there. In his office, he will take the class. Beautifully, he will take. Constitution also, writs, constitution law. Complete that part of it was covered by Mr. Raghunathan. And so what I'm saying is, I was taught by some of the best lawyers in Chennai, best teachers in Chennai, I should say, of law. And okay, so I'm not getting any answers on the query pad. I shall assume that you know it, but you don't want to tell me. So having said that, so basically a cognizable offense is one where a police officer can arrest without a warrant. That's all, simple. A cognizable offense is one where a police officer can arrest without a warrant. So judicial review is not needed. What type of offenses could be cognizable? Tell me. What type of offenses could be cognizable? Right? Very heinous offenses, murder, rape, offenses which are, looting. These are all where a police officer has the right to arrest the person without, any warrant. See, let us say that a person is a pickpocket, is snatching a purse and running. The policeman chases him and catches hold of him. Now, thereafter, he cannot say, "You wait here. I will go to the court and I will get a warrant and I'll come back." So he can immediately take him to the police station, and thereafter, of course, he'll be on remand. Let's see what you are all telling. See, somewhere you caught on to this point. Non-cognizable, non-bailable. Cognizable, non-bailable. Beautiful. Where bail, cognizable means where bail can be granted. No, I think Sumit is right in terms of non-bailable. See, but then you should understand why it is non-bailable. Okay, cognizable offences are non-bailable, stricter, arrest without notice. Beautiful, J. Srivastava says arrest without warrant, not notice. It's called a warrant. See, what is the warrant? You see, the police is the executive, and I think it's very, very important for you to understand it. Now, as never before, the need for everybody to understand the meaning of democracy. Now, as never before, we have to keep on asking ourselves, what is it that the Constitution promises us? Okay, what is it that the Constitution promises me? Okay, nothing more. In fact, the United States of America has a 2-page Constitution. I don't know if you've seen this. It's called the Declaration of Independence. It's a 2-page. The founding fathers of the United States simply got together and said, we no longer belong, we are no longer subjects of the king, promise our citizens, blah, blah, blah. That was a declaration of independence. And whatever they left out, whenever the government tried to make 15 amendments to the constitutions of the United States, smallest constitution. Okay. I know my voice is slipping. Please don't, I know my voice is slipping. My internet connection is a little unstable. Okay. So don't bother about this. It will correct itself. Please don't waste your time putting up messages. Inshallah, we'll continue without any problem. Okay. As I was telling you, the United States Constitution is a 2-page constitution. I'm not trying to say it's just 2 pages. I'm saying with 2 pages and certain number of amendments, these guys have got one of the best democracies in the world. Whereas our constitution is the longest constitution in the world. Okay, drafted very carefully by a group of experts headed by, of course, our Dr. B.R. Ambedkar, and we have one of the best constitutions. And what does this, today, we are even asking, what is the big deal with this constitution? I think we have reached a stage where some of our citizens even say, let's do away with the constitution. Okay, so long as we are having our happiness, so long as we are happy with what's happening to us, why constitution? The constitution grants us. And see, these provisions relating to bail, cognizability of an offense, have their root in the fundamental right of the citizen. You see, the United States of America promises its citizens only 3 things. Okay, it doesn't promise anything more. You know, in our country, we have so many directive principles of state policy, fundamental rights, blah, 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 reservation, this, that. There they have nothing. Just 3 things: life, liberty, okay, and the pursuit of happiness. So, life, liberty, and that's it. Every citizen has the right. Any disturbance of this right, every court is ready to protect him. Okay, so now tell me, if a police officer has to arrest a person, can he just let them walk into somebody's house and take him? I suspect you, I take you now. Oh, sir, he has to go to the magistrate, okay, or the jurisdictional magistrate, and he has to satisfy him that there is a prima facie case. Some evidence should be produced, something. Of course, it is up to the judge to decide whether the evidence is satisfactory. All he has to prove at that point in time is a prima facie case. Obviously, because only after he arrests him and some amount of questioning happens, only then, or even that person may plead guilty, that comes next. But even to do an arrest, the person has to go to the judge and get a warrant. Any offense other than cognizable offenses. Where if it is a cognizable offense, where it can, cognizing means seeing, realizing, knowing. So when I see a crime being committed, the police officer cannot go to the court or magistrate and get a warrant. Yeah. Okay, so he can immediately take action. Or the police has an information about a potential crime being committed. Okay, so they can actually have a sting operation and then catch this guy hand in glove. At that point in time, they can arrest him. But for the sting operation, they need a warrant. Okay, but if they see the offense being committed at that point in time, for example, bribing, accepting a bribe, both giving a bribe and accepting a bribe, criminal offenses, they can catch him. So at that time, he can be immediately arrested and taken. That is called, so a non-cognizable offense is one where a police officer can arrest the person without a warrant. That is the correct answer. So, and by definition, it is non-bailable. Non-bailable. Okay. Sumit, all offenses involving fraud are not cognizable. Okay. Because sometimes, you may not have a prima facie. So basically, it's offenses like murder, theft, looting, rape. Okay. These are all offenses where an arrest can be made by the police officer without any warrant. Because of the heinousness and because of the serious nature of the offense, the court does not have an automatic power to grant bail. See, normally for a non-cognizable offense, you can ask for bail and the court can give bail on personal, shall we say, bond. That's it. Say, on my own personal word, you allow me to go. So you're asked to sign, you can go home and you can come back, and every day or every week or whatever the court says, you have to come and sign. But if it's a cognizable offense, the court cannot give bail automatically. They can, but not automatically. Okay. So it's not a bailable offense, but granting bail is at the discretion of the court. Whereas for a non-cognizable offense, bail is a right. You can ask for bail because the offense is not so serious. Whereas cognizable offenses are serious offenses, heinous offenses. Letting this guy or lady go out, maybe, and I use the word lady very, very carefully because I can give you 100 other cases where heinous murders have been committed by ladies. One case where, a girl takes her husband on a honeymoon, and the girl and her ex-lover, they kill him in aircard. They kill the boy in aircard, and they throw the body, and they come back to Chennai as if nothing has happened. And then slowly the police unravel it. She has to be arrested, period. It's heinous. So no question of, if she wants bail, she has to ask for it, prove it, give valid reasons why the court should let her go out and commit one more murder. So, but for a non-cognizable offense, bail is automatic. Okay, this is why. So I hope you got the point, because some of you are right. Anjali is also right. All cognizable offenses are non-bailable. All non-cognizable offenses are bailable. But that is why. Why is this so? Because cognizable offenses are heinous, are very HEINOUS, very terrible. Okay, and therefore the bail cannot be granted unless the court honestly and sincerely feels there is a need for a bail there. Right? It's not an automatic petition. Your bail petition will not be heard. Okay, bail, go. No. So bail itself will be heard separately. Okay. Okay. Having said that, so they want to be very clear. All offences under the Companies Act shall be deemed to be non-cognizable, which means if the police or somebody want to do anything, they have to get a written complaint. Okay. The court also, if it wants to take any action, it has to receive a written complaint. Now, who can complain? That is the next thing. Who can complain for the offense under the Companies Act, which is alleged to have been committed by any company or any officer there? Who can make a complaint? Okay, now think about this, right? Think about this. Again, I don't know if I've told the story to you before, but again, there's a gentleman studying for CA. He's come all the way from Odisha, staying in Chennai, studying for a CA, and he's staying in a mansion in a small place called Tribunal in Chennai, where most of the CA students sort of lodge. It's a mansion where they get a room, bed, a table for studying, and that's it. And they study till they realize the dream of becoming a chartered accountant. Now, the point here is this guy, every day he wants to study for the exam. He goes to the terrace, and there as he's studying for law or MAFA or whatever, the next door terrace, he sees a lady, putting up the clothes on the washing line, on the clothes line, wash clothes, and she's crying because every day he's able to hear the noise of her husband beating her. He beats her. He comes home in the evening after 7 or 8. He is fully drunk. He beats her, and this lady is crying every day. At 11 a.m. when she's putting up the clothes, this guy is moved. Mr. Mishra from Bhubaneswar or Cuttack is moved. He says, I have to do something about this. So he goes to the Tribunal police station and he lodges a complaint. Now, first of all, does he have the right to do this? That is the real point. Now, assuming that he has, as a concerned citizen of the country, he goes to the court, he goes to the police, and he complains. Who is the proper plaintiff? I mentioned this when I was talking about the rule in Foss versus Harbottle. I hope you remember. So this guy, that husband will be brought to the police station for an inquiry. Invariably, the wife will come running, beating her hand on her chest, and she will look at Mishra and say, you cursed fellow, who are you to do this? He is my husband. He will hit me. He will do whatever he wants. Who are you? Okay, now what will Mishra do? Keep his mouth shut and go, because who is the proper plaintiff? Who can give the written complaint? Right. So for the Companies Act, who can give the written complaint? The registrar. Obviously, because he is the man enforcing the law, right? So if he finds that an offense has been committed, he can make a written complaint, which is what prosecution is all about, right? In some cases, the shareholders or members of the company can complain because they may be affected, right? And lastly, any person authorized by the central government in that behalf from the ministry including, see here, the regional director and deputy directors are also there. If you remember, go back to your investigation. One of the actions that can be taken by the investigating officer is to file a criminal proceeding. So that would be the complaint. Okay, the person authorized by the ministry giving a complaint. Okay, then and only then any action can be taken on the offense, which is why all offenses under the Companies Act are non-cognizable. Okay, they are cognizable only on written complaint. Okay, so cognizance of offenses relating to issue and transfer of securities and non-payment of dividend. Okay, then immediately once you say securities, you'll have to go to the Securities and Exchange Board of India. SEBI can also give a complaint, especially insider trading, violation of the takeover code. In all those cases, SEBI has the right to prosecute or give a non-cognizable means action cannot be taken without a complaint. Okay. That is the point. Except 447. I hope you remember 447, which we covered in miscellaneous topics. Those are cases where there is a fraud. As I think that's what Sumit means, because he studied the law, so he's one upon us. So he says 447, any offense under 447 which involves fraud, okay, is cognizable. Which means if for example, in case it is he's doing it, for example, go there, ask this guy and take him in, no questions asked. Then he will be asked to just come. Then he can go to the court. He can move a bail petition. It's not that cognizable offenses he cannot move a bail petition. He can. The court is not automatic. Okay. List of offenses given are relating to 447. All these sections in the Companies Act speak about, all these sections speak about fraud under section 447, right? Just give me 1 minute. Hello? Yeah, could you busy my agenda? I'm so sorry. So I'm sure we've come across these sections. For example, when I was conducting the classes last session for the intermediate or IPCC students, we spoke about 34, 36 and all in connection with prospectus and so on, and 38. We spoke about prospectus, and all those cases there was some sort of a criminal act or a fraud, which means directly it goes to 447. So I think now I know where Sumit is coming from when he said fraud. Absolutely correct, sir. Fraud, offenses where fraud is involved and 447 is involved. Then so the fraud is a very general 47. Under the Companies Act 2013, under 447, the offense is cognizable. That's it. Another, again, these are though unconnected, these are related topics. There is something called the Mediation and Conciliation Panel. Now, later on, when we discuss Arbitration and Conciliation Act, we'll talk about mediation, because we'll talk about the various methods of alternate dispute redressal, ADR, alternate dispute redressal, and why mediation and conciliation are good. See, what happens is, going to court is possibly not the best thing that you can ever do, okay? Because as I already mentioned to you, courts take a long time. Courts take a long time. Okay, I may mention this again when I come to arbitration, but right now let me make this point, because courts can take a long time. And in fact, there's a famous case, a fictitious case. If you read Dickens' Bleak House, you will find Dickens talks about the cases of Jaundice versus Jaundice. Jaundice versus Jaundice is a fictitious case. There is no such case in real life. But Jaundice versus Jaundice is such a case where The case has been going on for 40 years. And nobody knows what that case is about. There are easily about 150 lawyers are involved by so many people. It's basically about a property, okay, and who will inherit it. But there are so many petitions and so many cross petitions that so many advocates, nobody knows the totality of jaundice versus jaundice. All they know is that if jaundice versus jaundice orders coming, they will receive a substantial amount. That's all they know. So that is jaundice versus jaundice, very peculiar case where it will take a long time for courts to finalize. Right? It happens in India also. Don't worry. Don't think that India does not have its own share of jaundice versus jaundice cases. Any legal proceeding will drag on. In fact, even income tax proceedings sometimes will keep dragging. Sometimes they survive the death of the individual. I'm not joking. I had a client, a very, very important lady. I will not tell who it is. She is the granddaughter of a very, very important freedom fighter. And she paid the tax in advance. Okay. Then the sale did not happen. See, they had three flats to sell. She was the owner of the land. And so through power of attorney, it was sold by her nephew. So the nephew was because he is the grandson of an important national leader, he said, I will not cheat. I want to pay. I said, sir, don't pay now. Wait till the registration of the document, then you pay. No. Now itself will pay. But unfortunately, the registration happened on 1st April, which meant one flat alone went into 1st April, which meant the tax had already paid. Now there is no way in the Income Tax Act to adjust this. When that was claimed in that year they didn't adjust this refund and they charged 234B and C interest. And this year, of course, they had 244 interest. But 244 is less than 234B. So there was a small difference which they had to pay. Now, again, this gentleman being a national leader, he said, this is unfair. My aunt paid in advance. How can she be made to pay? I said, chalo, no problem. So we went to the chief commissioner for waiver. There's no section in the Income Tax Act or no provision for B and C. For A, it is there. B and C is not there. But in all these hearings, we used to take the whole story, who he is not. So the chief commissioner, IT was related. Everybody was impressed, but nobody could do anything. And so they never took a decision. The file kept on waiting for an order. Nobody was willing to pass a negative order against the daughter of a national leader and her grandson. Now the lady also passed away. That lady passed away. Then this gentleman also passed away. Now, but the file, I'm still getting notices. Okay, I'm still getting notices. I even went once and I told with folded arms, I said, nobody is alive. Please close. No. Okay, it's still going on. Okay, man is mortal. His disputes are immortal. Okay, his disputes are immortal. So how to avoid all this? Let's go for alternate dispute redressal and close the matter. So that is called mediation. So mediation is a good way of solving the problem. So normally there is informal mediation and conciliation, but here under section 442, the Act is trying to set up a formalized framework for mediation and conciliation. So by setting up a panel of experts, okay, that those experts will have such qualifications as may be prescribed for mediation and by the before the central government or the tribunal. So what will happen is you can actually become an expert. Okay, you can become a mediation expert. Members of the Institute of Chartered Accountants of India, once you become a member, you can become a mediation expert, and you can be empaneled with the central government or tribunal, so that these bodies can make a reference to mediation. So suppose proceedings are going on, especially oppression and mismanagement, the tribunal or the appellate tribunal can at any stage inform the participants, we are now referring your matter to mediation. Let's not waste our time here. Go for mediation, talk. Okay. Later on, when we come to ADR, I will tell you how mediation is different from conciliation and how both are different from arbitration. Okay. So these are three different concepts. Let us see what they are. Okay. Mr. Sumit makes further points. Serious frauds and offences, investigation office is also cognizable. Absolutely. So if I mention 447, you are only correcting me by saying SFIO is also cognizable. Absolutely correct. Serious fraud investigation office is also, again, because these are heinous offenses where the offenses cause so much damage, so much pain to people because of the nature of the fraud, which is why public interest is involved. People, shareholders at large, listed companies and all, SFIO can take over. So there again, it is cognizable, which means without a warrant, a person can be arrested. Okay, but after the arrest, the person has to be produced before the magistrate within 24 hours. If he's not, then there's a special writ called writ of habeas corpus that can be issued against the person. Okay, but then at this rate, the writ of habeas corpus itself may become history. So I don't know. Okay, because I don't know if you know about a case in Tribunal when two father and son were beaten up and in the police station while under custody. They were not produced before a magistrate. See, there is something called magisterial custody and police custody. They were under police custody, okay, and they were killed. They died because of brutality. I don't know. Nothing is proved. So it's all sub judice, okay, means it is still under the review of the court. But having said that, it's a fact that the father and son died while in police custody, where they should have been produced before a magistrate. Okay, so something very unfortunate. So which all this goes to show that now as never before, we need to be aware of our constitutional rights. Okay, I think instead of studying more about technology, we should know more about constitutional rights, because the very technology that is making life easier is slowly whittling away, slowly taking away our right to privacy under the Constitution and our basic constitutional rights. Slowly, we are slowly handing it on a plate to the authorities and telling them, take away my right, and finally we will be left with nothing. And at that point in time, we will regret, why did we do this? And every stage we are giving up our rights only because we see some benefit, which is very short-lived. Whereas the loss of freedom, liberty, freedom of speech, these are invaluable. Okay, you might ask me, why am I saying this? Because we are an independent institute. We are one of the bulwarks of independence still left in this country. I'm not joking. I am not joking. We are still one of the bulwarks, one of the supports. The Institute of Chartered Accountants of India is still one of the bulwarks of this country. We still represent independence. Yes, a government company, if a chartered accountant is appointed as an auditor, we can say, I will not sign. No government on earth can make me sign. And I can give the reasons why I cannot sign. Okay, that is where our independence happens. I mean, I'm not trying to waste your time, but then this is something you may not even understand. Okay, in fact, I don't know. I don't know if you appeared for a hearing with your senior or even on your own. See, when you are in those days, today it's all faceless. Okay, see how we are losing this right. We are surrendering this right and saying, "Chalo, no problem. You take it. Because see, in a hearing, a hearing is a quasi-judicial proceeding. A hearing before an officer of the NCLT or a DCIT is a quasi-judicial. He is a quasi-judicial authority. He has to give. Once he becomes we'll see that little later when I come to tribunal, I'll tell you why this is important. A quasi-judicial authority has to abide by the principles of natural justice. One of the simplest principles of natural justice, a reasonable opportunity for the other person to be heard. The views of the other person should be recorded and taken into account in the final order. Very important right. A violation of this right automatically results in appeal. Straight away you have a right to appeal. Because forget merit. Merit comes later. Okay, and so on. But then we are slowly giving away this right and saying you can do whatever you want with me. Okay, which means, see, all officers of the executive will not be honorable and honest. I'm sorry to make this comment. You can't trust the executive. There are officers who are honorable and honest. There could be others who are not. So power should be restricted to the executive. And judicial review should be always available so that at any stage, the citizens' rights can be protected. I mean, this is a broader principle which I thought I would share with you today, because this topic gives me the opportunity to talk about it and gives you the opportunity to sort of think about it. Okay? That's about it. Don't form opinions and give negative views and all that, because there's nothing, just you have to think. My rights are important. Okay? I had an officer once who was simply, the minute I entered the room, he started abusing me. He said, "You are a fraud. Your chartered accountants are frauds, blah, blah, blah." I said, "Chalo, sir, what is your problem? Produce all the details." I said, "Here are the details. Take it. You're not producing it properly." I said, "Please tell me what is not proper. I'll correct it." "No, no, you're talking arrogantly." Then he said, he wrote in the order sheet, he wrote the office, the representative behaved arrogantly, and he insulted the officer. Then I said, then he signed it and he said, "You can go." I said, "I can't go." "How can you say you can't go? I'm saying you get out of my room." I said, "Sir, you can't ask me to get out of this room because the proceeding is still not over." "What do you mean proceeding is still not over?" I said, "Sir, your order sheet you have written, now give that order sheet to me, because I have the right to, you have to get my sign on it. Have you taken my sign on it?" "Ah, yes, sir, sorry. Please sign." I said, "I'll sign." Then before signing, I wrote, the representative hereby submits that he was not arrogant. He spoke with all humility and produced the details called for and expressed his willingness to appear any number of times and produce any details called for. He said, "What are you writing essays?" I said, "Sir, it's not your order sheet. It's the government record. It's an evidence in a court of law. You've written something, you have your right, you've done it. Now I have my right and I'm finishing it." So I wrote and I signed it. And I put the date there. I said, "Please take it. Now I'll go." "Hey, no, don't go, sit down." See, the guy who told me to get out of the room now says, "Srikanth, don't go, sit down, sit down, sit down." I said, "Why should I sit? My job is over, I'm going, you go on, you pass your order. I have an appellate remedy. Under this law, I have you pass any order you want, Baba. That's all you can do. After that, I'll go and appeal, and this record will come there. This record will come to the CET appeals. Your order sheet will come there. And I will ask the Commissioner of Appeals, sir, when I did not speak arrogantly, how can he say I spoke?" And that's it will be you. Then he realized that he has been very childish. He had been very childish, you see. So then he said, "Srikanth, what can we do now?" "What can we do? You started the game here. You close it." I said, "No, let's, okay. You should also not irritate an officer." I said, "I have not irritated you. It's not a problem. But if you feel bad, okay, chalo, one sorry will not hurt me. Sorry." Okay. Now tell me what to do. Huh? What to do? Tear up that paper and throw it, write another order sheet properly. I will sign it and I will go. That's all. Matter over. Now, why I'm saying these are fundamental rights. You and I, as chartered accountants, need to know our own rights and need to protect them. Okay, is what I am trying to tell you. Okay, good, Sumit. What you're telling is correct about data, but I think it's much more than data. It's much more than data. Data is the least thing. Data, okay, chalo, take it here. If Google wants to know what toothpaste I buy, please enjoy, or what condom I buy, please, not a problem for me. That is nothing. There are other rights that are being taken away, which are very serious. Okay, which I don't know. I'm sure no CA student would ever have even heard of novels by George Orwell, The Animal Farm or 1984. That is the nightmare that awaits a country which surrenders, the people of a country who surrender their liberty for the sake of a little improvement, for the sake of a little economic growth. If they surrender their liberty, that's it. Okay. So I know this sounds a lot like a speech, but then better to, because I'm a senior member of our institute, and I tell you, the Institute of Chartered Accountants of India, you can see the eagle with its outspread wings on the slide that I'm showing you here. It's always there. The eagle is watching. Okay, you and I, we are the watchdogs of everything, not only finance accounts. We are the watchdogs of property. We are the watchdogs. We should be the watchdogs. If we are not the watchdogs, then we are committing an offense and we should be punished. Okay, but once we are the watchdogs, we should be respected for being that, and we should be given the due regard by the executive and treated correctly, is what I'm trying to say. Okay, incidentally, the corollary of that story is that person and I became great friends. After this incident, he became very close to me, and he always used to remember that incident when, I did this, and because he was a young rookie officer who had never met, who had always thought CAs are bad. Then he realized, by then, I was easily 15 years his senior in age, and he was just a rookie. But then, sitting in that seat, he has the power. Okay, and that power, the seat has to be respected, sir. Person is different from the seat. I always respect the seat. No way. Even if the person is As I'm growing older, the people sitting in that seat are 25 years younger than me, 20 years younger than me. No problem. I still have to go because I'm not going to the, I'm not bending or bowing to the person. I'm bending or bowing to the seat. Okay, these are all small conceptual and thoughts that I'm putting in your mind as a senior, as part of overall, shall we say, mentoring of my younger members of this institute. This is something that always happens in coaching classes. We have been mentored by great people like past President R. Bhupati. I don't know, I'm sure in North or West also, East, there are people similar to the names I'm mentioning. Our past President T.N. Manohar, and even chartered accountants like R. Shivakumar in South. For that matter, my good friend, V. Patabi Raman, of course, MPV and others. So these are, I have been mentored by great people. CA R. Bhupati, CA T.N. Manohar, and CA Gurraj Upadhyaya, all famous chartered accountants from South, who are my mentors and teachers, and not just in terms of teaching me subjects like income tax or finance, but values. And these values are important. I mean, I thought this opportunity, possibly before I complete company law, I thought, and in the context of the topic I'm teaching, values are more important than subjects. You may be good at numbers, good for you. You may be good at memory, good for you. Good for you. Okay, I'm not saying that's bad. Good for you. But values become more important than all this. So, mediation and conciliation panel is a very good idea. It's an opportunity for chartered accountants to sort of take part in the quasi-judicial processes and sort of take the weight away from the courts, because the courts may refer the matter to the mediation and conciliation panels, where there is a set of rules have been framed, and within the framework of the rules, the mediator can dispose of the matter. The panel can dispose of the matter referred to it within a period of 3 months from the date of such reference, and forward its recommendations to the central government or the tribunal. Okay. Under the Arbitration and Conciliation Act, mediation will usually result in a mediation agreement when it is happening within the framework of the High Court. Here, under the Companies Act, the reference would be given by the panel. Okay. So obviously, if any person is aggrieved by the recommendation of the mediation and conciliation panel, they may file objection to the central government or the tribunal or the appellate. Finally, based on the reference made by the mediation council, the tribunal or appellate tribunal or central government will pass the order. Once they pass the order, then the normal appellate remedies will be available to the person, right? Now, so let me, the time now is something like 7:35. As usual, I will take a small break from now on. From now, say by around 7:45, we will meet again. 7:45, we will meet again. Thanks for listening to all this, and don't go away. Come back at 7:45, and we'll continue our discussions. deserved break. And as we move on in our journey in understanding the judicial aspects of corporate law, Companies Act 2030, I welcome you back again. Okay. The next section we are going to see is called section 444. Now, where there is a prosecution of a person, there may be an acquittal. Okay, not on compounding, but actual acquittal. You see, a person may go to court, the prosecution may go to court, the person appears, and there's an argument in his defense. The court sort of agrees that he is not guilty, and they acquit him. In which case, this section provides the central government, okay, to direct any company prosecutor or any other person to present an appeal from an order of acquittal passed by any court other than High Court, and an appeal presented by such prosecutor or other person shall be deemed to have been validly presented to the appellate court. So, when the order is passed by a magistrate court or a sessions court, against that you can make an appeal. The central government will go on appeal to the High Court against an order of acquittal. Right? Why they would do this? Because they feel the guy is still, they feel he's guilty, and that possibly certain things were not considered by the lower court. So they will take this before the higher court and say, do you think this is right? Should he not be convicted? Then the higher court, or the High Court as it is called, may decide, yeah, this guy should have been convicted. Or again, he may be acquitted by the High Court. Okay. Similarly, this is, see, alag alaga, 444 is over. Now we go to another totally different section called 446, capital A. The court or the special court, while deciding the amount of fine or imprisonment under this act, shall have due regard to the following factors. Okay. So while fining, they can say, what is the size of the company? Is it a large company having tens of thousands of shareholders, or is it a small company where there's not much public interest involved? The nature of the business carried on by the company, because is it something vital and important? For then, suppose a huge fine may cause financial problems, and the company may not be able to continue the business, and that could cause problems. So these are all things to be considered, right? Similarly, injury to the public interest, what will be the degree of public interest is something they might want to see. How will the public at large be affected by this company, or it's continuing or not continuing? The nature of the default, as I said, how serious is the offense, and repetition of the default. See, once first-time offender, a slap on the wrist and say, don't do it again. Second-time offender, you have to be a little more serious. Why is he doing this? Repetition of the default. Similarly, if a one-person company or a small company fails to comply with certain provisions, such company and officer in default of such company shall be liable to a penalty which shall not be more than 1/2 of the penalty specified. This is something you might want to remember. See, sometimes, in a crazy mood, some paper setter may decide, let me test this guy on 446A. So they might say, small company is going for this thing, and they might even give the penalty amount to you. And they will say whether the small company can be penalized. If so, what is the quantum of penalty? Then, okay, or they may not give you the penalty, but they will say, what is the quantum? Even if you don't know what the penalty is, you should know that a small company or a one-person company should have to pay should not be not more than 1/2 of the penalty specified, right? I mean, small things. Suppose sometimes they want to be really tricky. They want to get into some nook and corner where nobody has read. They might ask you a question here. So just be aware. Put it somewhere in your mind and sort of store it away in the examination. If you're getting it, you can. Now we come to the adjudication of penalties. Adjudication means the adjudicating authority, okay? The officer of central government, there's a process by which he has to do it, right? So when there is an offense, then the adjudicating officer has to follow a certain procedure. So the central government may appoint any of its officers not below the rank of registrar. So who is above the rank of registrar? The regional director, the assistant directors, deputy directors, the registrar. You know what many of us don't realize is that the registrar is possibly the lowest in the hierarchy, but he is the face of the MCA in those days. You met him, and so you thought the RD is his boss. The regional director is the registrar's boss. Okay, and there are so many. So these adjudicating officers are appointed or nominated for adjudging a penalty. So what should be the penalty to be levied? That will be decided by the adjudicating authority. That is why when the matter is appraised of the adjudicating authority, sometimes the regional director, it's better to compound it at that time. But friends, compounding can happen at any time. Even after prosecution has been proceeded, you can go for compounding till final order. Any time you can go for compounding and get out. Okay. So before adjudicating a penalty, the adjudicating officer shall issue a show cause notice to the concerned party, right? SCN. This is a very important thing because again, the show cause notice will simply say, these are the offenses we have committed under the Act. Show cause why you should not be prosecuted under those sections. That's all. So you have to give a reply. And as in all cases of MCA, it's a virtual mode. The reply to such notice shall be filed in electronic mode only within the period as specified in the notice. Usually they give you 30 days time. Okay, and the adjudicating officer may extend the time up to 15 days on sufficient cause being shown. So you can get some. You can file a letter saying we may be given some time, some reason, valid reason. Okay, sufficient cause. You can't simply say I'm not ready. Give me 15 days time. You should say we are not something. Our MD is traveling abroad. Something which should, I don't know. The adjudicating officer has to decide. The word adjudication itself has judiciary in it, which means the adjudicating officer has he sits as a judge here, and he has to take a call. Okay, as I told you, the income tax office, the assessing officer is an adjudicating authority, and he assessing officer, and it's a quasi judicial function. Okay, so it's a quasi means kind of similar to, but not exactly the same. Quasi. So a quasi judicial body is one which is like a court, but not a court. So it has some of the powers of a court, and also the duties of a court, but not all. Okay. So the adjudicating officer should give us show cause notice, reply is received, then a hearing is fixed. So on that, and giving a reasonable opportunity of being heard. As I told you, the adjudicating officer is a quasi judicial body. He is performing a quasi judicial function. So you cannot just like that pass an order. Unilaterally, the executive shall not pass an order. Okay, should give a reasonable. See, that reasonable is very, very important. 15 days minimum, you should give some time for him to prepare and come. And if he's giving a valid reason for adjournment, you should give it. Okay, and then you should give him enough opportunity. Then you pass the order, because that order would be a good order. Similarly, the adjudicating officer cannot simply say, according to me, he is guilty. You should prove a case. You should show how he committed the offense, which violation is there, how the violation is proved, and then say, in view of the above, I'm passing the order. So it's called a speaking order. 30 years now, I've seen about 15 speaking orders. That's all. 15 speaking orders. I still love them. And some of them, I have gone on appeal and won. But they were speaking orders. Beauty of a speaking order. What is a speaking order? When I'm appearing before the Commissioner of Income Tax Appeals, the assessing officer will not usually come for CAT appeals. If at all the CAT appeals wants some inputs from the AO, he would send the file back with asking the AO to give his remand report or whatever. But then, even if the assessing officer is not there, he should speak through the order. His presence should be there through the order, which is why, many cases, the CAT appeals will not even read our written pleadings. They will even sometimes ask me to read the order, which is why in my, when I give a written submission, I always quote the assessing officer first, because then I say, he's saying this, but he's wrong because blah, blah, blah. Then only the submission becomes logical. Okay. So this is again more of a practical input for you I hope you find it useful. Okay. So on the date fixed for hearing and after giving a reasonable opportunity, they will pass the order as he thinks fit in writing, including an order for adjournment. So I'm giving a gist of the section. If you read the section, you'll go to sleep. Believe me, I went to sleep. Okay. So I woke myself up and I tried to get into this. So any person aggrieved by an order made by the adjudicating officer may prefer an appeal to the regional director having jurisdiction in the matter. So assistant director, deputy director, they pass an order. You can go to the RD. But then tell me, how successful will you be with the RD? Seriously, I'm asking you. Okay. But still the power is there under this section. You can go to the RD. Why? Because you see, he is the boss. These guys are his, guys. How? Unless there is a unless there is an enmity between these two people, that's a different story. Otherwise, he will not normally let down his colleague 1, 2. The colleague also will not pass the order without consulting the RD. So I seriously don't see how this works. But still, again, RD is sitting in a quasi-judicial position. He should cease to be the boss, and he should become the impartial adjudicating authority. And he should read it, and he should see, okay, see. So every appeal shall be filed within 60 days from the date on which the copy of the order made by the adjudicating officer is received by the aggrieved person, and it will be in the form mentioned. The RD may, after giving the parties to the appeal an opportunity of being heard, pass such orders as he thinks fit, confirming, modifying, or setting aside the order appealed against. So I don't know. I have not seen any statistics, but I wish under the RTA you can get a statistics of how many orders were passed setting aside. Okay, the chances were modifying or usually confirming. Okay, in which case you have to go to the next level. Okay, now so let's stop. Let's keep this in mind. Later on, finally, I will cover NCLT and NCLT, where a company or an officer of a company or any other person having already been subjected to penalty for default under any provisions of this act again commits such default within a period of 3 years from the date of order imposing such penalty passed by the adjudicating officer or the RD as the case may be, it or he shall be liable for the second or subsequent default for an amount equal to twice the amount of penalty. So try to remember this. I mean, if I were in a nasty mood and I'm setting a paper, maybe I will take areas like this and I will do it. That will be very unfair on my part, but then I'm in a nasty mood, believe me. So we pray to God that the guy setting the paper for your exam should not be in a nasty mood, that, he should be happy and his wife should give him food correctly and sort of things, okay? All that emotionally he should not be affected. No, don't worry. Nobody will be emotionally affected like that. But somebody, when a paper setter wants to really show his greatness, then he may go here and he will try to do this. Now we go to NCLT and NCLT, National Company Law Tribunal and the National Company Law Appellate Tribunal. Okay, both have been constituted to provide a single window for settlement of all disputes relating to companies. So I've given here the membership. Who can be the members? Who are all the members? And what is their qualification? So the chairperson is the chairperson of the appellate tribunal. So slowly, gender neutrality has come into the law. So we don't refer to chairman anymore. We call it chairperson, means it could be a lady or it could be a gentleman. Okay. Then you have a judicial member. Okay. A member of the tribunal or the appellate tribunal appointed as such and includes the president or the chairperson as the case may be. So a judicial member obviously would be a member of the bench. He would be a retired high court judge or a person who is competent to be appointed as a high court judge. Right? Then he can come here. A member, whether judicial or technical, of the tribunal or the appellate tribunal, and includes the president or the chairperson as the case may be. So the word member means any member. You also have technical members. Now, technical members are obviously people who have expertise or knowledge in certain special fields, including, but not restricted to, accountancy, taxation, finance. So which means a chartered accountant possessing the requisite experience can become a member of the NCLT or the NCLAT. Then you have the president of the tribunal. Then you have the technical member, a member of the tribunal who is appointed as such. So you have chairperson, you have a normal member, you have a technical member, you have a member could be either a judicial member or it could be a technical member or the chairperson. Okay, then you have the president of the tribunal. Now, I've given you a sort of a chart here, which you could use to understand how it works. Okay, a summary of the provisions relating to appeals. So, when you are aggrieved against the order of an adjudicating authority or officer or the regional director, then directly you'll go to the NCLT, okay, NCLT. The appeal to the NCLT should be filed within a period of 45 days from which, you go to the NCLT, and then against the order of the NCLT, you can file an appeal within 45 days from the date on which a copy of the order of the tribunal is made available. In case there is any delay, then the condemnation of delay for filing beyond 45 days, but within a further period of 45 days on sufficient cause being shown. So against the NCLT, you can go to the NCLT, and the appeal should be filed within 45 days from the date of receipt of the copy of the order, okay, to the person aggrieved. Then you go to the own appeal. Then NCLT, here's the case. Okay, if you receive a negative order, then you go to the NCL. You go from the NCLT directly to the Supreme Court. So that way, the NCLT is sort of equal to the High Court. Okay, is the point. It's sort of equal to the High Court, and appeal against the NCLT order should be filed within 60 days. Here also, Supreme Court can give condemnation. Again, remember, you can go on appeal against the NCLT only on a question of law, right? Similarly, where the appellate tribunal has passed an order with the consent of the party. See, matter comes before the tribunal hears the matter, then it says, this is the order, are you okay? Then they say, I consent, possibly because he is going for a plea bargain. He's saying, okay, I'll accept these offenses, you let those offenses go. Whatever it is, when a combined order is being passed, you cannot go on appeal against that. Where part of it is with consent, you cannot go. Where you have agreed, yes, I committed the offense and I will go by it, then you go for compounding, some route you take. Again, you cannot go on appeal before the tribunal, right? In fact, if you want compounding, you should totally surrender your appellate remedy. Otherwise, you cannot go for compounding. Okay. So against NCLT, then NCLT, then finally you have the Supreme Court. So framework is like the adjudicating officer, the regional director, the National Company Law Tribunal, NCLT, finally Supreme Court. Okay, this is the hierarchical framework of the judiciary operating within the framework of the Companies Act. But once an appeal goes to the Supreme Court, you will go by the rules of the Supreme Court. You will not be bound by Companies Act anymore. The order of procedure before the Supreme Court will be followed. Possibly constitutional provisions also will have to be seen. Okay, so I kept on repeating quasi-judicial body. The sections very clearly say NCLT and NCLT are quasi-judicial bodies, which means what? They can regulate, they are like the court, but not a court. They can regulate their own procedure based on natural justice. Okay, so some of the important things you should understand. Tribunal, NCLT are all quasi-judicial bodies. They can regulate their own procedure based on natural justice. And one of the important principles of natural justice is a reasonable opportunity to be given to the opposite party of being heard. Okay, the Latin maxim that operates here is called audi altram partem. Audi means hear. Altram partem is the other party. Audi altram partem means hear the other party or give an opportunity to the other party to give his view. Okay, is the point. The tribunal, now that's why, because they are quasi-judicial bodies, the tribunal and appellate tribunal shall have the same powers as are vested in a civil court under the Code of Civil Procedure 1908 while trying a suit in respect of the following matters, right? This Code of Civil Procedure, again, I'm sure I mentioned Macaulay in an earlier session and you are all angry with me because I was so happy about Macaulay. So the Code of Civil Procedure is again a Macaulay ka child. Macaulay sort of had a major role in drafting the Code of Civil, Indian Penal Code. Okay, the Indian Penal Code, which is a shopping list of penalties or shopping lists. That's all I can say. It's like an online shopping list where on the one side there is an offense, and the other side the penalty or the imprisonment or whatever for each offense. Okay, so now, so you decide what you want to commit, and then you say what you have to pay. I mean, repeat offenders must be doing something like that, right? So summoning and enforcing the attendance of any person and examining them on oath. Okay, I'm sorry, I'll just make it a little smaller so that we can. I don't know, it's becoming too small now. Okay, let's see. Yeah. Summoning and enforcing the attendance of any person and examining him on oath. See, this is a power that is usually with the court under the CPC, but it is available with the NCLT and NCLT. See, what happens is, once an oath is administered, you see the oath, I'm sure you heard it, that I am telling the truth, the whole truth, and nothing but the truth. Okay, so the three things are affirmed and then usually sworn on a Bible. But then if the person doesn't believe in God, then here there's nothing he can swear on, but still he can say, telling the truth. Usually to solemnize it, the holy book is bought and he is asked to swear on the holy book by keeping his right hand on the book and lifting his left hand and keeping it like this and saying, I swear to tell the truth, the whole truth, and nothing but the truth. Thereafter, if he tells a lie, there's a technical name for it. A lie told under an oath is called perjury. 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 Perjury is a separate criminal offense. Under the CRPC, perjury, or even under the Evidence Act, perjury, giving false evidence under oath, is a criminal offense. Right? So normally when they are on oath, supposed to tell the truth. Right? Requiring the discovery and production of documents. Okay, discovery and production of documents. See, discovery is a very complex matter. It's not like the discovery of America by Columbus. Here the discovery is, see, what is meant by discovery, I'm the plaintiff or I'm the complainant, I'm going to the tribunal and I'm filing the petition. The entire paper book will be given to the prosecution. Similarly, the prosecution should give the entire, the register, the lawyer or the representative of the ministry should give what all records they have in their hands. All the documents on which they are relying should be produced to the other party. Both the parties should have access to all the documents on which each of them is relying. This is called discovery and production. Discovery is a very important aspect of a judicial proceeding, because if you do not disclose a document in discovery, you cannot produce it in court. Suddenly you can't stand up, many cinemas, you see that things happening, where suddenly one lady will come rushing in and say, see this paper. No, you can't do that. The whole matter has to be put in adjournment, then the whole matter will go for discovery. Both the parties will have the opportunity to see it, examine it, then and only then matter can be produced in court as an evidence. Till then it cannot be produced as an evidence. Maybe the judge will see it and say, hey, this throws a totally different thing on this. Let's stop here. The case doesn't continue. Both of you get a copy of it, go through it, come out and come back with your views. We'll argue again on this. That's why it takes a long time. But in movies, that one single paper, the judge will see immediately, oh, yes, then the whole thing. It's not possible. No judge can do that because they each have a discovery, opportunity for discovery, okay, and production of documents and all that. Similarly, that's what I'm saying. The defendant cannot suddenly come and say, this is the document and all. Why didn't you produce it at the time of discovery? What was happening at that time? You have to again provide it. So then it has to be verified, authenticated, everything has to be done. Similarly, sometimes a mere affidavit could also be used. Sometimes evidence can be given. You are giving the statement under an oath. Again, the question of perjury is there. You are not supposed to give false evidence or false statements in an affidavit. Right? Now, so subject to the provisions of 123 and 124 of the Indian Evidence Act. Okay, they are, see, these two sections of the Indian Evidence Act deal with how a public record can be requisitioned. So courts have the power to do this under the Indian Evidence Act. That power is available to the NCLT under this law. They can call for any public record or document. Also, they can issue commissions for examination of witnesses or documents. You see, suppose a person is extremely ill or old and they are not able to come to the court or to the tribunal and give evidence or witness, then the tribunal will authorize a suitable advocate or a qualified person, a company secretary, to go to the witness wherever he or she is, and certain questions will be put by the commissioner of oaths. This person who is going there, usually an advocate, is called a commissioner of oaths. So the commissioner of oaths will first administer the oath, and then he will ask the questions which the tribunal has put, or whatever questions need to be asked, and then he will record the evidence, and then the witness will sign it, and it will be countersigned by the commissioner of oath, and that will be filed before it will become an evidence in the proceedings. Okay, so they can also dismiss a representation for default or deciding it ex parte. Now, again, the word ex parte is sometimes wrongly translated. Ex parte means without a party being present. No. Ex parte means, ex means arising from. Ex means arising from. Parte is, of course, party. Ex parte means arising from one party. See what happens. Let us say that the ROC is filing a complaint. Matters before the NCLT. This man has gone on appeal to the NCLT. The regional director is appearing regularly, but the opposite party is not coming. He's simply wasting time, not appearing and not giving any data, nothing, no appearance, nothing. So immediately the registrar can stand up and say, he being one of the parties, he can say, or his representative can say, sir, decide it ex parte. I am asking you to give an order. Come on, he's not going to come. That itself proves, you pass an order. So after giving possibly one more opportunity, saying that it will be decided ex parte, the matter will be decided ex parte. Or at the instance of one party when the other party is not appearing. That's called ex parte. Setting aside any order of dismissal of any representation for default or any order passed by it ex parte. Okay, because it can also set aside any other matter which may be prescribed. So these are the powers of both NCLT and NCLT as the powers of courts, right? We already saw this, so I don't want to waste your time. Now, only one question has been asked in the exam on this topic. Agreed by an order of the NCLT dated 5/5/2018, passed without the consent of the parties, Madhuruk Limited decided to file an appeal before the NCLT. Meanwhile, the employees and officers of the company went on a strike from 10/5/2018, demanding higher pay and allowances, and as a result of which the operational and management activities were badly affected. The strike was called off on 15/6/2018. Thereafter, the appeal was filed on 25/6. So the order of NCLT, we shall presume that the order was received by Madhuruk Limited on 5/5. Okay, 5/5 it received the order, right? On 5/5/2018. The appeal was actually filed on 25/6/2018 before the NCLT with a player for condoning delay in filing the appeal, right? I'm sorry, it was filed on 25/6 before the NCLT. Single judicial member of NCLT started the hearing. Now, whether the appeal is admissible, okay, the maximum period allowed for condonation. But I really don't see here what is the problem, because the strike starts on 10/5 and ends on 15/6. Your time for filing an appeal is 45 days. Okay, the appeal should be filed within 45 days, which means 5/5. We are talking about, let us see if you have 45 days there. Okay, So how many days, if you take, not including 5/5 because on that date you received it. So from 6/5 to 31/5, that's about 25, yeah. So exactly short of 45 days. It is exactly short of 45 days, but still the appeal is admissible because NCLT has the power of condonation of delay, right? NCLT has the power for condonation of delay beyond 45 days, but within a further period of 45 days. So this is well within the further period of 45 days. Therefore, the maximum period allowed for condonation is 45 days. Now, this is something you can actually see when you're asked questions in 3 parts. No, answer those questions. You know why? Because when there's a single question having, say, a single answer having 6 marks, try to keep it as an option not to answer. It's a simple psychology. See, 8 marks, 3 questions. So maybe whether the appeal is admissible, if it is well argued, that will get something like 4 marks, right? And the remaining will get 2 marks each. Okay. The appeal is transferable to a bench consisting of 2 members. It can be transferred to a bench. So on 8 marks, 4 marks are reserved for the first one. Now, if you write the answer reasonably right, on 4, he may give you 3. Whereas on 6, he may not give you 4. On 6, he'll give you 3. On 4 also, he'll give you 3. It's a simple psychology. That 1 mark extra, is a proportionately it's taking you higher, which is why you have to always answer. And even if you don't know the final one, is the appeal transferable to a bench consisting of 2 members, and you take a sort of risk and say the appeal is transferable, you're right. Even if you're wrong, you get 0 there. If you're right, you might get 2 straight marks here, 2 straight marks in maximum period, and 3. So 4 plus 3, 7 out of 8 or 6 out of 8. Okay. For the entire 6-mark question, if you go, chances are you get 3 or maximum 4. So this is the difference. That's why I always suggest you write questions that have 3 parts or broken up into parts like that. So like the other day, these topics are such that, the time allotted may not be fully utilized. But then, as usual, I have some of those practical problems that I'm going to talk to you about. In the meantime, today is not the last class. We have the next month, we are going to start economic laws. So we'll be talking about Foreign Exchange Management Act and all. But today is technically the last class for me. I don't know about other faculty. For me, for corporate company law. So if anybody is still listening and not gone to sleep or dead, so boring, huh? I know, I'm so sorry. But if you're still there listening to all this, then, and if you have a doubt on any topic, anywhere, use this opportunity to, ask a query, clarify the doubt. You can use the opportunity. So, yeah, Sumit, thank you. I think somewhere I feel, okay, it's sort of a limited audience there. No problem. And I allow you for a thing. Can we have questions if you want? In the meantime, I'll open up the practical problems and I will start giving you the problem and discussing the problems. But if you still want to ask me totally, topic covered by me, okay, not connected with today's topic. You can ask me any topic asked by me, taught by me in my sessions, appointment of directors, qualification of directors, meetings, powers of directors, meetings of the board and powers, compromises and arrangements, miscellaneous companies incorporated outside India, and prevention of operation and mismanagement, miscellaneous topics, and tribunal. I think these are the topics which I had the good fortune of discussing and sharing with you. So if you have any doubts, please ask me. If you anytime during the proceedings, feel free to send in a query on the query pad. I'll definitely see if I can answer it, and I will answer it. Now I'm going to take up from where we left off in the last class. We stopped, I think, at 6 or 7, problem number 6 or 7. 6 we got over. Yeah. I think 7 also was over. So we have 8, right? 8. 8 is an interesting question. Problem 8 is an interesting question, again from the 2019 November, which is pretty near. Because I think after 19 November, I don't think Institute had any classes thanks to Corona. So, I don't know. So, now, Mr. R holds directorship in 10 public companies and 11. As usual, I will give Sumit and others an opportunity to give your answer, and then we will discuss the correct answer. Mr. R holds directorships in 10 public companies and 11 private companies as on 31/5/2019. One of the above private company is a dormant company. Apart from the dormant company, on 30/6/2019, a private company in which Mr. R is holding directorship has become a subsidiary of a public company. Now, so you know the position as on 31/5 and you know the position as on 36. In the light of the provisions of the Companies Act 2013, examine and decide the validity of holding directorship of Mr. R with reference to number of directorships as on 31/5 and as on 36. If you remember, we discussed this long ago. I do not know how long ago, when we talked about qualifications of directors, maximum number of directors, then we saw maximum number of directorships. Okay, so let's have so was it valid on 31/5? Okay. On 36, what happens? I know it'll take a little time for you to take. Yeah, I thank Ms. Anjali for confirming that there are no doubts. In fact, Mr. Bhupati used to give the story to us after a class. You know, a faculty asked the students, ladies and gentlemen, any doubts, any questions? So immediately they said, sir, only doubts, no questions. Okay, because the thank you was saying no doubts. Okay, and but then questions can always come, because questions could be there. And in fact, at this point in time, I want to award Mr. Sumit Jain the award. He is the master of questions. Okay, and I always believe, you know, sometimes when I address entrepreneurs on MIS, Management Information Systems, and financial MIS and stuff like that, I always tell them, it's not knowing the answer, it's about knowing the right question. Okay, anybody can have an answer, but only the intelligent people will have the right questions. So let's see some of the questions, and let's see. So, okay, I'm sure answers will come flowing in as I'm talking. In the meantime, on 31/5, Mr. R is director of 10 public and 11 private. One private is a dormant. Now, as you know, for the number of the companies not to be included in this total number, limit of total number, dormant company should not be included. So remove the dormant company. You have 10 public, 10 private, total 20, well within the limit. The limit is 20 in all, out of that 10 public. So satisfied, right? What happens on 36? On 36, one of those nasty companies becomes a subsidiary of a public company. Okay, so yeah. So Sumit confirms, correctly says, as on 31/5, 31/5 valid J, because on 31/5, he is a director of 10 public companies, TK. He is the director of 11 private companies. Out of that, one is dormant to be ignored. Nicolo, then what happens? 10, which means 20. 20 is the maximum. He is there, 10 public, total 20. Okay. What happens on 36? This private company becomes a subsidiary of a public company. Therefore, for removing, private companies are to be removed. Okay. But when it becomes a subsidiary of a public company, it has to be included, and it becomes a public company. So his number of public companies becomes 11. It goes above the 10. So that's why it cannot be, he is not valid on 36. Okay. Yeah, see, on 31/5, yeah, valid, sir, as dormant company is exempt and 10 public. So on 31/5, it's valid. On 36, no. Okay, so he has to resign. Of course, he can resign from any other public company also. The choice is this. It's not that only this company has to resign, but he cannot hold more than 20. or 10. He is given time to resign and he has to come out of one of the public companies. Yeah, on 31/5 and continuously one company is a dormant company. Okay, then it is valid. Sumit says yeah, valid. So valid. But on 36, because this private company becomes a public company, what I will do, I will open up that PowerPoint also so that you could we could refer to that in case you have a doubt. We could refer to that. So let us see. Just give me 1 minute to do this. Okay. Yeah. Maximum number of directorships. Yes. Okay. Just more of a, you can even call this a revision. Okay, so it's 20 including alternate, 10 public. Public company includes, this is why public company includes private company, which is either holding or subsidiary company of a public company. Okay, so the minute a private company becomes a subsidiary of a public company or a holding company of a public company, it becomes a public company. Therefore, there's a violation of the limit, right? So what I have here on this PowerPoint is called interpretation issue. Okay, I don't know what interpretation issue is that. I wish I could meet all of you in regular classes, where we could actually talk. It'll be I would love to do this. I don't know. Anyway, okay. Actually, as when I was 20, 22, 23, 25, even 42-year-old Srikanth, he never used to sit. My guru always used to say, he will not sit. Then as he became older, he became 70, he started sitting down and teaching. And so I'm slowly, as 55, I'm sitting. I enjoy sitting. I'm now enjoying sitting down and talking. But actually, it's not a good idea. I like to walk around, come down, come to the student, stand next to him, talk to him, and then move back to the dais, stuff like that. I think I'm missing all that, but then not a problem. So long as you are there. Okay, Sumitji, interpretation issue, Baba, and I agree with you. Okay, on 36, there is a contravention, Shubham. You are right, Shubham. Beautifully said. It's a simple problem. See, this is a simple 4-mark problem now. You should take, see, you know what, time is also very important here. For this answer to this problem, you should not take more than 15 minutes, 10 to 15 minutes. Okay, with neatly written answer, should not take more than 10. Even if you follow my 4-step policy, simple, line by, see, all this will take single line. Okay, that's all. And you will get your answer. Applying the law, first, second, right? Neatly write the conclusion. Whether a company has power to specify lesser number of companies, yes, they can. What they cannot do is higher number, but not lesser number. Okay, so now what happens is, in case he is having in more than one, then he should choose, and any company he can choose. Finally, he should have not more than the limit, and he should resign and intimate the choice. Okay, that is the point. He should resign. He should resign and inform the choice. Right now, so this is how you have to understand it. Right. Right. I already worked out problems there in a different way. See, expect something like this in the exam, because they have asked it in the past. So expect something like this in the examination, because they have not asked such questions. They have not yet asked this type of a question. So you can expect something like this in the exam, where they give you a list. We already did this in class. So do expect something like this in the exam, and I'm sure you'll not be disappointed. Okay. In fact, okay. This being a sort of a last session for company law, I'm going to tell this. I'm going to share with you, maybe after the problems, if I have time, I'll do that. Otherwise, I'll do it in another class. Let's move on with the problems. Once we finish that, then maybe I can share one more tip on how to prepare for the exam and stuff like that. Okay. There's an interesting problem on section 180. Queen, let me open the appropriate PowerPoint so that I will not, at that time, I will not waste your time. I will quickly open it up. And so this is on meetings of board and its powers. It's a huge, humongous topic. It has two, I'm sorry. That's me when I was young. I mean, younger than what I am now. Okay, so Queen Construction Company Limited acquired 60% of the equity paid up share capital of ABC Limited. So what happens by that acquisition? What happens? Queen Construction becomes the holding company of ABC. And agreed, Sumit. I agree. See, the problem is, sorry, Sumit is continuing his problem about interpretation. Thank you, Baba. I agree with you. Okay, that see, one of the above company is a dormant company. Yeah, I don't see any problem there because on 31.5, he is in 11 private companies. One of the above private companies is a dormant company. That's all. That's all. I don't see, but then I can understand. Be careful. In the exam, you have to be very careful. Okay. That's all I can say. So between us, no problem. I accept. But examiners can be very, very cruel. Ashaya patate lokaha karmana bahun chintaya ayurushin. He says, you know, this is Jnaneshwar. He says, Yamasya karuna nasti. He says, Yamasya karuna nasti. We see, we have so many things in our life we enjoy. But when Lord comes, death comes, he has no, like that, the paper character has no karuna nasti. He has no karuna. He will simply give wrong and go. Okay? And what to do? So that is why I'm saying be very careful. Jagrato jagrata. So Queen Construction Limited acquired 60% of the equity paid up share capital of ABC Limited. As we already saw, it becomes a subsidiary. With that mind, let's go. The board of directors decided to avail additional exposure of 10 crore from the, 10 crore from the bank. So they want to borrow 10 crore from the bank. So they also give you the data. Let's come back to this a little later. Further, ABC Limited approached Queen Construction Limited to grant a loan of rupees 25 lakhs and also to stand as a guarantor. So Queen Construction Limited is going to give an intercorporate loan to ABC Limited and also to stand as guarantor. So it's going to guarantee or provide provide a guarantee for repayment of loan to be sanctioned by a bank to ABC Limited. So the two loans, 25 lakhs and 10 lakhs, will be utilized by ABC Limited for its principal business activities. You, being the financial advisor of the company, advise the board of directors about the procedure to be followed to avail additional exposure of rupees 10 crore from the bank. Also evaluate whether the loan guarantee given by Queen Construction Limited is valid. So these are two different questions. So separate them. First question, procedure for availing additional exposure. 181C, loan to be given to ABC Limited, intercorporate loan, right? 186, 185 also will cover. 185 and 186. Okay, two are because 185 and 186, right? They are asking you a question, is valid according to section 185. So they are very clear. Sir, no interpretation issues here. Evaluate whether the loan or guarantee given by Queen Construction Limited to ABC Limited is valid according to section 185, because 186 is also covered. They are not asking you about 186. So they're not asking you about 186. Don't waste your time writing about 186. Though, strictly speaking, it's an intercorporate loan. So 186 is also covered, right? Now, okay, but then 186, let's see. I want an answer now. Before that, let's go back and see. Let's see the data. So you have authorized equity capital, then you got issued and subscribed equity share capital, and you got paid up equity share capital. So which one should, I think, they're being so smart, they're thinking that somebody may not know that it's paid up share capital. Wow. I don't think anybody in this audience is so, confused. It's only paid up equity share capital that has to be taken, which is 20. Okay. Capital reserve. Chhod do. You should not touch it because it's not to be considered. Revaluation reserve. Chhod do. It should not be taken. No. Okay. General reserve allowed because it's a free reserve. Okay. So for calculating, see what happens. 181C says the board of directors cannot borrow in excess of paid up capital and free reserves. Free reserves are reserves available for declaration of dividend. So if you look at it, if you look at things from that angle, capital reserve and revaluation reserve are not available for declaration of dividend. But be a little careful now, because capital reserve, there is a small exception there. I'm sure we discussed it then. I'm just repeating it for your benefit. I'm saying for a capital reserve, you have to be a little careful because you have to see if that reserve is out of, shall we say, merger or amalgamation or something like that, or any capital structuring issue, or is it arising from sale of a asset where the profit has been realized in cash. There is a clear-cut view that where capital reserve is nothing but profit arising on sale of assets, where the profit has been realized in cash or cash equivalent, then it can be used for dividend. So my suggestion, if you're a little smart, you'll write a note there saying it is assumed that capital reserve is not out of sale of assets realized in cash. Therefore, it is not considered. Your best thing is to write a note. Don't sort of assume that the examiner would understand. Assume that just like he is thinking we are such buddhus that we don't know that it should be paid up equity share capital and not issued and all, or for that matter authorized. If he thinks we are buddhu, let us also think he is buddhu. Yeah. Let us say, hey, you don't understand. I'm telling you, I'm assuming this. Okay, because he'll be actually, but one thing, having said that, he'll be smart. If he is a smart examiner, he'll be happy. Wow, this paper, this person, depth of knowledge is so good that they're writing this point as a note. Okay, so general reserve can be taken, which means 20 plus general reserve 3, my paid up capital and free reserve is 23 crores. Absolutely correct, Sumit. 23 crores, hitting bullseye, 23. Now, so the borrowing cannot be more than 23. But the amount to be borrowed together with the amounts already borrowed shall not exceed the paid up capital, the aggregate of the paid up capital and free reserves. So this is the wording of the section. So the amount to be borrowed together with the amounts already borrowed. So amounts already borrowed. Now there you have to again be very careful. So you have an open cash limit for working capital requirement, which is repayable in 3 months. Similarly, loan obtained under the hire purchase agreement for acquiring vehicles. So, and finally, you have a long-term borrowings from banks. Now tell me which one to be considered. Can I have a total? So Anjali says 51 minus 23. BSc, free reserve. Pass SR. Okay, I'm not able to. 51 greater than 23. 51. Yes. Anjali ji, how do you get 51? Already borrowed 15 plus 1, 16. So 23 minus 16, 7. 7 can be the maximum amount which can be borrowed. Correct. So now they want to borrow 10, right? So that is, I think, Sumit's point I'm able to understand. So 15 plus 1, 16. We should not consider the repayable in 3 months because there is a short-term borrowing. So which means 16. So I don't know where that 51 is coming from, right? So, and how do you get 51 minus 23? Not very clear. Okay. So cash credit should not be taken because it is repayable in 3 months. So therefore, it should not be taken. So you have not taken it now, Sumitji. You have taken only 15 and 1. Correctly you have done. And Anjali also, see, Anjali is right, but I don't know how she gets the Yeah, temporary loans are not considered. Okay. Where is the temporary loan? Yeah, temporary loans which are repayable within 6 months. With obviously exception, we'll see it in another next problem where the exception is where the loan is taken for financing a fixed asset, it should be considered. Okay, but in this case, it is for working capital. Therefore, that 5 should not be taken. So, yeah, correct. 16, maybe, I don't know, 16 and minus 23, 7. So the company, the board of directors on their own can borrow only up to 7 crores. But here they want to borrow more than 10 crores. Therefore, as rightly pointed out by Anjali, SR means special resolution is needed. Pass SR. Okay, good. Thank you for that answer. Good. Right. Regarding the next one, they want to now give intercorporate loans and investments. I'm sorry, loans to a company. So can they do that? Where Queen Construction Limited is owning 60% of the equity paid up share capital of ABC Limited. Can they do that? Is it, what is the, Subhamji, you are also correct. Up to 7 crores can be borrowed without the consent. Otherwise, you have to pass a special resolution. Fantastic, sir. How about the next part, next limb of this question? I will wait for your answers because this is a Pakka revision, and I would prefer that you answer to the best, so that I'm also happy that you have. I mean, you are already intelligent, but to some extent, what I taught has influenced you, is what I feel. Yeah. See, my Hindi is like our Prime Minister's Tamil, okay? It has its limitations. I'm doing it because I want to relate to you. So I have had disastrous experiences with my Hindi when I traveled in the north. So I speak Hindi, sort of, thoda, begin. I can get along with servants and drivers and all. But if you start talking to me in Hindi or the way Sumit, I can read. I can read Devanagari script, but I cannot speak. My loss. I realize that it's my loss that I'm not able to speak a language which is spoken by a majority of my country brethren. Okay. So, okay, answering this question quickly, the simple point here is 185 does not apply to a loan given by or a guarantee given by a holding company to its subsidiary. So, matter over. So, section 185 does not apply. So, answer is correct. Anjali says, but then, as you rightly point out, Anjali, your answer is good. I mean, because of the query pad, you are not able to type out much, but in the examination, you should give the reasoning. Use my 4-step method. Facts, law, apply the law to the fact, conclude. You are correctly given the conclusion. The guarantee given or the loan taken is valid under section or according to section 185 of the Companies Act 2013. Moving on, the Articles of Association of Messrs. DEF Limited, a non-government company, restricts the company to contribute to National Defence Fund in any financial year for a sum not exceeding 5 lakhs. So they've restricted it to 5 lakhs. The articles, actually it's wrong English, the articles are silent about contribution to bona fide charitable fund and to a political party. The company earned net profit during the last 5 financial years as under, right? So the articles are silent about charitable fund and to a political party. Okay, so now this is clearly a question of powers of the board. Now the board of directors is proposing to contribute in July 2019 for the first time during the financial year 1920. Okay, so they've been in existence. So they want to contribute 7 lakhs to National Defence Fund, 3 lakhs to a bona fide charitable fund, 5 lakh to a political party. Company seeks your advice on the following matters. Yes, all of you have correctly given answer for 185. Company seeks your advice on the following matters. A, what is the appropriate approving authority? The quantum of contribution that can be made, the mode of payment of such contribution, right? So that can be easily answered. It should be made only by check, not by cash, right? And sorry. Now, 7 lakhs to National Defence Fund. The articles of association of the company restrict giving of dividend now. So, any quick reactions about, let's do it one by one. 7 lakhs to National Defence Fund. Can they do it? If so, how? Similarly, 3 lakhs to a bona fide. Let's finish National Defence Fund. Basically, for National Defence Fund, there is no limit. And the amount is left to the discretion of the board. The section says whatever amount the board feels appropriate can be given. So the board of directors can give 7 lakhs even though the articles of association is saying 5 lakhs. Because if there is a conflict between the Act and the articles, the Act shall prevail. Amending article is definitely an option, but even if they don't amend the article, section will prevail over Act. Section says contribution to national fund can be done by the board at its discretion, and the appropriate amount as decided can be given. So 7 lakhs can be given even without, right? No need for any, for which one, for, can you be a little more specific when giving answers so that I'll know which question you are answering? Otherwise, I'll make a mistake. So no need to amend the articles. You can directly give this because the section very clearly says what can. Next is 3 lakhs to a bona fide charitable fund. Now, bona fide charitable fund 181. That is governed by, what shall I say, there is, first of all, there is a limit. Up to the limit, the company board can give. Above the limit, they have to pass a special resolution. As rightly pointed out by Ms. Anjali, it's 5% of the average net profits of the immediately preceding 3 financial years. So we are giving this, we are contemplating this in 1920. So I have to go back 1819, 1718, 1617. So if anybody has done the computation, okay, so that's like 45 plus 25, 60, 70, 70 plus 20, 90, right? So that's 5% of the net profits of 90. So on 90, that's about 4.5, right? So they can give only 4.5, whereas, I'm sorry, is that right? Yeah, last 3 years profit, as rightly said. So last 3 years profit is 45, 50, 70, 20, 90. 90 into 5%. Let me do the calculation because I'm weak. I get 4.5 lakhs, right? So they want to give 3 lakhs. Not a problem. They can do that. They can give the loan. They can give a contribution to the charitable trust because it's less than. They're giving only 3, whereas they can go up to 4.5. So the board itself can do this. That's the point, right? The appropriate approving authority is the board. The quantum is 3 lakhs can be given, and 5 lakhs to a political party. Now, political party, no limit. You can give earlier it was restricted to average of 3 years. There was another 5%, but no limit now. 5 lakhs, whatever you want. You like the party, give it. 5 lakhs can be given to a political party. Board itself can do it. There should be a disclosure of the amount which is so contributed by the board in the annual report. So I mean, see the greatness of our lawmakers, that because to become a lawmaker, they should be members of a political party. So see how beautifully they have framed the law, where they say for a charitable contribution, they are restricted to 5% of the immediately preceding 3 financial years. But for political contribution, no limit. As God only knows what, I mean, I don't know. Similarly, under the Income Tax Act, 80G, 101 formalities before you can claim deduction for contribution to charity, but no limit for contribution to political party claim. Seriously, for the man who thinks life is a comedy, the lawmakers of this country are also comedy. So, problem 11, Pristar Limited, an unlisted public company with an annual turnover of 700 crores, entered into a contract of purchasing of raw materials from Messrs. PTC Private Limited during the year 2018. Right? Messrs. Pristar Limited appointed Mr. Sudhir, a director of the company, to act as in this deal on behalf of the company. Mr. Sudhir is also one of the member of PTC Private Limited. So, one of the directors is a member of the other party. So, Mr. Sudhir settled the transaction for 85 crores. After a few transactions, the contract, there is a degradation in the quality. Further, in a board meeting, this contract was challenged, considering it as a related party transaction. During this period, Mr. Sudhir was appointed as director in a newly incorporated company, Mrs. Raga Limited. Now, in the light of the given facts, what is the legal position of the contract entered into between Mrs. Pristar through its director, Mr. Sudhir, and Mrs. PTC Private Limited? So, now, board cannot enter into it because it's a related party. It needs the approval of the shareholders. Why? Because it's 10% of the annual turnover or 100 crores, whichever is less. So this is 85, which is more than. So 100 crores or 10% of the turnover. 10% of the turnover is 70. Therefore, it is more than 10%. So 85 crores. So definitely you should have gone for approval of the shareholders by way of special resolution. Board or a single director cannot take this decision. It has to be approved by the board. So in addition to that, Sudhir should also have made a disclosure at the board meeting where it came up. Assuming he's made, you may make that assumption in your answer. Assume that Mr. Sudhir has made the required disclosure under 192. Assume that, okay? And oh, I'm so sorry. Absolutely correct, Anjali. See, that is the problem. Hey, let's go back to the earlier one. I made a mistake there. Sorry. So 90 by 3. Sorry, that is 30. 30 into 5% is 1.5. So it's violating. 3 lakhs is violating. So you have to go to the members for a special resolution. So that's. Thank you, Anjali, for that correction, and God bless you. So I hope you all got the point. It's 30, 45 plus 25 plus 20, 90 divided by 3 for an average. On the average, we have to compute 1.5. Okay, I demonstrated what could happen when you're in a hurry by my own mistake. How it is possible for you to make silly mistakes in the exam. So all of us are human, okay? But an error in the exam could be very, very costly. So what did I learn from this? I learned that whenever I make a calculation, I have to recheck it once or twice before I confirm it. And ideally, I should write stuff like this in pencil so that later on I can come and quietly erase it and write the right answer and go, so that the examiner wouldn't know that I made a mistake in the first place. Okay, this has happened to me many times in the exam, because as you can see, I'm a very careless person. So I made this type of mistake, but I do the correction and that's it. So coming back to our TriStar and Sudhir, Sudhir should have disclosed, maybe he did. It transaction requires approval of the shareholders. It was not obtained. So it is in violation of the, it is in violation of section 188, which means the penal consequences of section 188 are there. Plus, Mr. Sudhir, the company can, collect the, see, there's a degradation in quality. So any loss incurred by the company should be compensated by the director concerned. Also, more importantly, if he is convicted under section 188, subsection 1, then he is disqualified from being appointed as a director. But in this case, yeah, you are right, Sumit. The company can give more than 1.5, but they have to pass a special resolution. Absolutely correct. So coming back to Sudhir again, Sudhir, now, is Sudhir disqualified? Is Sudhir disqualified No, because only conviction under section 188. If you remember our discussions on earlier on compounding, first there should be an adjudication, there should be a show cause notice, then the matter should come up before the adjudicating authority, blah, so on and so forth. Then matter should go to the court, so on and so forth. So any appeal against, so that means he is not yet convicted. So if he is not yet convicted for an offense, then he can be appointed as the director of Raga Limited. So Fortune Limited, under 3 different scenarios, okay, wants to borrow money, right? So the CEO, Mr. Murali, you know something, I used to always complain in my earlier lectures on company law that, there were no, South Indian names in the institute question paper on company law. It used to be always, Shah, Mehta, like that. Never I used to find a South Indian name, like my name Srikant, or better than mine, you got Srinivasan, Subramanian, Venkatesan. These are all hard to pronounce South Indian Madrasi names. So nowadays I find a lot of these names are getting into. I saw a name called Jnana Vinayakam in one question. Jnana Vinayakam, my God, I don't know how it will be pronounced by our Prime Minister. But Mr. Murali is again a nice, Murali of course could be a North Indian name also, but then we also have the name in South, Muralidharan, Murali, okay, and all that. So Murali is the, the flute, okay, of the Lord. So the point here is going on. The CFO seeks your advice, so you go there. Let's look at the cases. First of all, what is the equity share capital? 150. Preference share capital 50. So what is the total paid up capital? 200. Point. Paid up capital includes preference share capital also. Plus I should add securities premium and I should add free reserve. So 270 is already a number there. 270 is already a number there. No problem. Paid up share capital includes both equity and preference. Then let's look at the loans now very carefully. The working capital loan repayable on demand from Sigma Capital Limited. Alert, though it's a working capital loan, it's repayable on demand. So a loan which is repayable on demand, short-term loans repayable on demand or within 6 months should not be considered. So Sigma Capital loan should not be taken. Similarly, cash credit limit from scheduled bank, in this case, it is repayable on demand. So it should be ignored. So I will not take that. Which 6 months loan for purchase of plant and machinery. Though it is 6 months, it is for plant and machinery. It's a proposed loan, but should be considered for the limits. Because though it's a 6 months loan, it is for thing. One more interpretation I will tell you. See, the section says, does not include temporary loans. Okay, repayable on demand or within 6 months, other than, okay, loans taken for the acquisition of capital or any capital expense. So, which means the temporary loan for plant and machinery is not to be considered while calculating the limit. Aggregate of the loans already taken takes to be taken. Okay, so I'm sorry, 6 months loan for purchase of plant and machinery, where it's a plant and machinery, then even though it is 6 months, it should be considered. That's the point. Similarly, 24 months loan for purchase of plant and machinery should be considered. So both are for plant and machinery. Though 6 months is a short-term loan, it should be considered because it is for acquiring plant and machinery. So the total of these two comes to 40. So which is what you see there. So in the first case, okay, the total is sorry. I'm sorry, I made a mistake there. Sigma Capital Limited is not a banker because the section says only those short-term loans from the company's bankers are not to be taken. Since Sigma Capital Limited is not a banker, it is considered, which means you got 50 there. The proposed loans are 40, 50, 40, 90. So total is 90, less than 270, no problem. Next case, 50, 40, 20, 60, okay, 110 total, less than 270, not a problem. The third case, the amount total of the loans existing and proposed exceeds 270, and therefore that should be taken, right? And the cash credit from the scheduled bank is not taken. 6 months loan for purchase of machinery is not there. I made this mistake about Sigma Capital, which is not to be considered because it's not a banker. So it's not exempted. It has to be taken. So that's the point, right? This is a quick question on scheme. It's almost 9. Okay, maybe I'll leave it. It's not a problem. It's not a big deal. Okay. As we come to the end of our classes on company law, let me thank you all for wonderful participation. I really loved interacting with you, all of you, Anjali, Sumit, Subham, okay, Jagadishan, and all that. I had some more earlier people who were active, but then they slowly dropped out. Mr. Srinivas and Mr. Padmanabhan and all, they dropped out, or maybe dropped out of asking questions. I don't know. Maybe they're still listening in and learning, or I don't know what they're doing. I thank all of them. I thank all of you, and have a great evening ahead. And I look forward to meeting you again in the next session next month when we'll talk about the Foreign Exchange Management Act. Bye. Have a great evening ahead.